All right, good evening. Thank you so much to everybody that had the opportunity to come out tonight. And we appreciate you being here. I know your time is the most valuable thing you have, so we're going to try to be extremely judicious with it. Go ahead and tell you now, I'm going to have to exit the meeting at about 20 till 7. Have the opportunity to speak at a high school graduation tonight, so I'm going to try to motivate those young people to go out there and aspire to be the best they can be in the world. So with that, we're going to go ahead and call the special meeting to order. First, we'd like to start off with prayer and a pledge, so I'll ask you to please rise with us as we say the prayer, and then I'm going to ask Commissioner Lynchard to lead us in the pledge. Dear Heavenly Father, thank you so much for the opportunity to gather here tonight, God. I pray that you'll bestow wisdom and knowledge upon us, God, that are beyond our years. Lord, I pray that you'll build a hedge of protection around all the families that are represented here tonight, God, and we'll give you the praise and the honor. In Jesus Christ's holy name we pray. Amen.
Please join me in the Pledge of Allegiance. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And for anybody in the audience that may be wondering where our Vice Chairman, Commissioner Salter, couldn't be here today, he had a small back procedure done at the beginning of the week, but the fantastic news is I've talked with him, and he's doing great. The doctor actually said it went better than he expected, so he'll be back with us at our next set of meetings in June. And he does wish he could be here and wanted me to pass along his condolences. We have no old business schedule, and then our new business. We do it a little bit different than the zoning board, so I'm going to roll through these. I'm going to ask if there's anyone here to speak in opposition as I go through each one. If there is, just please signify by raising your hand if you're able to. If you're not able to raise your hand, you could just give me a yeah, I'm here, and we'll come back to that. And that way we can dispose of the ones that have no opposition first and get some of you folks out of here in a timely manner. So with that, if you'll follow along, we're going to go in order. The first item is 2019-SX-004. This is an appeal. Project applicant J. Hill. Location 6430 East Bay Boulevard, Gulf Breeze, Florida. And this is a request for a special exception to allow a temporary use of an RV for a residence due to a medical hardship. This is in Commission District 5. Is there anyone here tonight in opposition to this? Okay, thank you. We'll come back. Item number 2 is a 2019-V-030. This is an appeal. Project applicant Dirk Linhart. Location Soundside Drive, Gulf Breeze, Florida. Request is a variance to allow an existing accessory structure prior to the construction of a residence. This is in Commission District 5. Is there anyone here in opposition to this? All right. With that, I'll turn it over to Commissioner Lynchard. This is in his district.
Thank you, Mr. Chairman. Is the applicant here? Okay, Mr. Linhart. I don't have an objection to the placement of the accessory structure. However, I do want to impose a time limit. We don't want it to be open-ended. So if you will pull a building permit within 6 months, I would move that we grant the appeal and allow the variance with the condition that a building permit must be pulled within 6 months. And I do so without objection.
All right, hearing no objection, that item is moved. Thank you, sir. You're done. All right, item number 3 is 2019-CU-009. This is project applicant Terry Rowell. Location is 4733 Highway 4 in Jay, Florida. This is a request for a conditional use to allow a single-family residence in a highway commercial development district on 2.5 acres. Do we have anyone here in opposition to this tonight? Anyone here in opposition to this? All right, this was recommended approval unanimously by the zoning board, Commissioner Salter's district. So I'll take up the lead role, I guess, there for the district commissioner, and I'll make the motion without objection that we approve this request. Hearing no objection, the item's approved. Item number 4 is 2019-CU-010. The project applicant is Melanie Gentry. Location is 4541 Sabine Drive in Gulf Breeze, Florida. The request is a conditional use to allow the temporary use of an RV as a living quarter during the construction of a residence. Do we have anyone here tonight in opposition to this item? Anyone in opposition? All right, we're going to turn it over to Commissioner Lynchard.
Thank you, Mr. Chairman. Sean, our time limitation on the temporary use of the RV, can you state that, please?
Yes, sir, it's 1 year.
Okay. Given that, I believe they've met all of the requirements, and I would move approval of 2019-CU-010 without objection.
All right, hearing no objection, the item is approved. Item number 5 has been tabled, correct? Did you say that we were tabling that? I apologize.
Yes, sir, if that's the wishes of the board.
Okay.
There has been a request to table it this evening.
Been a request. This is a project on Harmony Lane in Gulf Breeze. I believe there's some legal questions to do with some of the concerns in there. They've requested a table. Would any members of the board have a problem with them tabling this until June or July?
It would be, well, if we table it from this meeting, it would be the June Board of County Commissioner meeting.
Okay. Any members of the board have a problem with that request as they work with our legal team to figure out some of the nuances there? All
I would
right,
ask if there's anyone in the public who would.
do we have anyone in the
speak
public
on
here to speak on behalf of this? Okay. Are you representing the applicant?
I am.
Okay.
Elizabeth Stry, AICP, representing Flynnbelt. We're actually looking at going back and requesting a variance, and of course, as y'all know, that's not a guaranteed approval process. For us to actually ever develop this, even with the rezoning, we're going to need that variance in place. So the tabling might actually, we might need more than just one meeting.
Yes, sir. Based on that, forgot about the variance request there, so the next agenda would be August for that, so it would probably be the August Board of County Commissioner meeting.
Okay. Are you okay with tabling it until August?
Yes.
Okay. Do any commissioners have any problem with tabling it until August? All right. No, and the attorney hadn't slapped my hand, so we'll grant your approval to table it till August, or I'll make that motion without objection. Hearing no objection, we'll table you till the August special commission meeting.
Thank you.
And I guess you'll coordinate with Sean as far as the notification necessary.
Absolutely.
All right,
Thank you again. Y'all have a good night.
Thank you. Item number 6 is 2019-R-022, project applicant BJL Sources Incorporated. Location 4460 Highway 87 South, Navarre, Florida. This is a proposed zoning to go from agriculture to highway commercial development in District 4. Do we have anyone here in opposition to this tonight? This was recommended unanimously for approval at the zoning board. Anyone in opposition? All right, I'm going to turn it over to Commissioner Peach.
Thank you, Mr. Chairman. This is down just the north end of 87 before Eglin property. It's the Yule Brothers Brewery area. They've been consistently improving that area with the growth of 87 and that. So this fits in with, I think, what we want to see on 87 with commercial property and things. They're looking at maybe putting a retail section or something in there. So there's been no objections to this, and the surrounding neighbors are all good with it. So I would recommend approval without objection.
All right, hearing no objection, the item's approved. Item number 7, 2019-R-024, HBL Properties LLC, location 4137, 4139 Plant Avenue, Pace, Florida. Existing zoning, mixed residential subdivision, R1M. Proposed zoning, highway commercial development. Do we have anyone here in the audience tonight? Okay, all right. We will come back to you. And also, just for the record, I apologize, I forgot at the beginning. If anyone was here tonight concerning item number 8, which is location Chumuckla Highway, project applicant Mike and Pat Dennis, case number 2019-R-021, it's number 8 on our agenda. This was the 40-acre request up on Chumuckla Highway. It was withdrawn, so I apologize if anyone's here, and I forgot to say that sooner. Okay, we're going to go back to item number 1. And again, this is project applicant Jay Hill, represented by Doug Walburn. And this is in Commission District 5, so this is Commissioner Lynchard's district. And do we have the project, or do we have the appellant here? Who filed the appeal? Okay, you will? Yeah, please come forward.
Mr. Chairman, just before we get started, item number 9 on the agenda, this was a large-scale public hearing for the third public hearing. I didn't know if you wanted to go ahead and address that one or not.
Okay, item number 9.
Yes, sir.
Okay, yeah, as long as we can. I didn't know if it was, we had to wait, but yeah, I apologize. Give me just a second here. All right, so I got to read this in the record. Note the following agenda item, 2019-R-015, is a large-scale future land use amendment. Following tonight's adoption, public hearing, the item will be forwarded to the state for final review. Project applicant is the Ball Family Partnership, location Woodbine Road, Pace, Florida. Existing zone R1, proposed zone HCD, Highway Commercial Development. Existing future land use is single-family residential, and the proposed future land use is commercial. This is 22.18 acres. This is in District 1. Do we have any citizens here to speak on behalf of this tonight? This is an item that the board voted on a few months ago. Okay, hearing none. I will make a motion that we approve this tonight so it can be transmitted to the state, and I'll make that motion without objection. Hearing no objection, that item's approved. Thank you. And we'll get to item number 10 after we dispose of these other items. All right, we're going back to item number 1, and you were the fellow that appealed it, so I think it'd be appropriate to give you the opportunity to speak first.
Yes, I'm Doug Walborn, and I live at 6430 East Bay Boulevard. Basically, what we was trying to do is take care of my mother-in-law. She's had some medical issues, and she lived in Tennessee, so we brought her down here so we could take care of her. Basically, we're the only ones in the family that are capable at this time to just keep an eye on her.
Okay, give me just a moment. We had somebody raise, okay. If you could come forward and let us know your side on this and what brings you out tonight, and that way we can hear from both of y'all, and then we'll open it to questions if we have any from the board members. If you, and just give Miss Amanda your name and address, please.
We did that already.
Okay.
I signed in.
All right, if you'll just give it to her, and that way, you can just say it right now. There you go.
I live at 6434 East Bay Boulevard.
And I'm Shirley Markey,
My
same
wife.
address.
Same address.
All right.
We live together. We were here a month ago to object to this, and he was granted an appeal. Nothing has been done. I objected on that it didn't meet the qualifications for what he was looking for. It's a travel trailer. He's got his mother, she's got to climb upstairs to get in it, and she lives alone in the travel trailer behind his house. I don't see how that's really helpful for the recommendation by the doctor to have somebody around to keep an eye on her. She's not even in the same house. They granted our objections last time on a 6-2 or 4-2 vote.
6.
And since that time, nothing has changed. The mobile home is still sitting in the same place that it was previously. It does not meet the requirements to use it as a separate residence. There was no site plan, I don't know about the electrical and the plumbing hookups to it, but I'm sure they're makeshift, as are most things over there. I also complained. I've been living out there for 30 years. My wife and I are both retired military. The tenant, who has permission from the owner of the property, has a letter from him saying, you can do anything you want over there. And I guess the county agreed, because that mobile home she's been living in it since June of last year. No repercussions for that. That was brought up at the last meeting. She's continued to live in it as far as I know, and it still does not meet the requirements that would make it proper for her to live out there. The yard next door is a mess. The last time I was here, there were 6 boats in his front yard. 5 of those boats he was doing upholstery repair work on. It's down to just one boat, or two boats out there now, one for upholstery repair. After the last meeting, I called code enforcement to complain about his bringing these boats over here, parking them in his yard, as well as his trailer, a shed, a tent, an add-on dock. He's building a fence out there now. It just looks terrible. In 2004, we lost our house to Hurricane Ivan. I had to build a nice new home at great expense. And I don't like seeing my property values run down because of the junk and businesses that are being operated next door. That's about all I got to say.
So we're very concerned about the potential hurricane hazard from the yards, stuff next door. He has, as far as I know, he hasn't provided a site plan, like in the criteria that the Planning and Zoning Board requested. We have provided a letter last time. You should be able to see that. And
Not only us, but 5 or 6 of our neighbors have also written letters opposing this. And I can't believe that the vote was 4-2 to let him, 2 to voting him to let him use it as a separate residence for his mother-in-law.
Jay Hill wrote a note on one of the forms that I printed out from the agenda, saying that he could do anything he wanted over there, boats, RVs, whatever.
And he's doing anything he wants with it.
And the owner does not live here, to my knowledge, and I really resent that. So hurricane safety, do you have my letter? from
Property
the-
values,
Property values, okay. That pretty much says it all.
I believe that if we didn't come here again tonight, second time, even though he appealed it for no reason other than he was allowed to just appeal it.
Right?
Is he going to appeal it again? Because how many times can he appeal it? She's already been living in there a year.
Right. Okay, so no, there's no, well,
It's an
technically,
inconvenience to me to come up here and object, because if I don't, he's going to get approval.
so there's
to do
no
that.
further appeal process with this board. He'd have the opportunity, he could, probably through a lawyer or himself, he could appeal it to the court system. Sometimes, occasionally, we do have people do that, and then, at that point, you can handle it with a court system.
Well,
but,
I just knew that if we didn't come up and object, that it would be approved, and
Understand. Thank you for being here.
So we're concerned about our property value, hurricane risk. Those are the major things.
Okay, all right. Do we have anybody else here to speak on this tonight?
is that it?
Yes, I think you're good for now. Haven't seen any lights come on with any questions from my fellow commissioners, so I'm going to turn it over to Commissioner Lynchard. This is in his district for any questions or make a recommendation.
Thank you, Mr. Chairman. I would give Mr. Walborn the opportunity to address the positions of the opposition.
I really don't have anything other than I'm putting a privacy fence up between the two properties because they don't like the way that I live. I've submitted all the stuff to Danny. The first time that I submitted the paperwork for the exemption, it got lost on the desk of Danny. That's why it took so long for it to get to court. And really, I feel like I'm being harassed for the way that I live.
Okay.
I've got cameras, I put live feed video cameras up all around the house. I do keep my boats out back. I found golf balls on the boats, around the boats, on my dock, in my backyard. I can't say whose did it. I've had gas taken off my boat. I've had equipment taken off my boat. So, I'm just trying to live and enjoy and try to make it easy for my mother-in-law. She can get up and down the stairs just fine. She, and with her being 80 years old, she kind of needed somebody just to take care of her and keep an eye on her, but she wanted her own space as well. We bought the camper before we even decided to have her, so if a hurricane did come in, we could use the camper to move out of the way of a hurricane or a storm.
Okay. All right, thank you. And how long has she been there? How long has the RV been used as a residence?
She's been in and out. We've went up to Tennessee and picked her up a few different times for her to come down just to see if she liked the area, if she could stand the weather. Maybe 9 months at the most.
Okay. All right, thank you. Unfortunately, I think that most of the objections here are based on the condition of the property, and our decision doesn't rest on that. It's whether or not we approve or deny the way you keep your property is up to you, the boats, things of that nature. So whatever we do is not going to impact that decision. In terms of the temporary use as a residence, all of the conditions are met other than the site plan, and obviously the RV's already there. We do have a letter from a physician certifying that the mother-in-law has a medical reason to be close to her family members so that she can be monitored safely yet still live alone. There is a 2-year provision for temporary use of an RV for medical purposes. I would approve the appeal, but I'm going to condition it on that starting 9 months ago, and we will revisit it at the expiration of that 2-year period, which will run from that date.
I have a question.
Commissioner Lyncher?
Commissioner Cole?
Never mind. I guess you probably just answered it, so he can reapply in the 2-year period if the conditions are the same with medical and stuff?
Yes.
Okay.
Yes, sir. He can reapply for one extension for another additional 2 years, but only after that point.
Mr. Chairman, or Commissioner Lyncher, would you consider starting it today?
Just trying to be consistent with
Okay.
the
I'll
code.
support
Been
you
there
on
for
that.
9 months. We'll run the 2-year period from that point that it started, if that's fine. Okay.
Excuse me, she's been in there since June of last year.
Okay, but we've got it down to 9 months. That's as close as we can
Oh, you
get.
said
We're-
9
All right.
months. I was
Hang,
here.
hang on just a second. We can't do the back and forth without coming to the podium, but it sounds like that.
It sounds like you've already.
If you want to come up and speak, I'm not going to deny you that, but you have to be there on the podium so we're in compliance with record keeping. You can address him, I just can't have it from out in the audience.
He's been a tenant over there for just over 2 years. The mother-in-law moved in a year ago, June of last year. It's almost June of this year. The doctor's excuse is just another way of free rent. He doesn't pay rent. He's business partners with this guy that owns it. The guy that owns it doesn't care what he does. Do whatever you want. Trash that yard as much as you want. Piss off the neighbors as much as you want. The county laws, they don't apply to you. I own the property. His landlord owns the property. The mobile home, or it's not even a mobile home, it's a travel trailer. We read the requirements, setback requirements. Doesn't meet them. Plot plan, site plan, doesn't meet them. Hasn't met them since June of last year. The county, the rules in this county, even with 6 neighbors objecting, that's overlooked. She's only been in there 9 months because he said she's only been in there 9 months. He could have said 2 months, you'd be saying 2 months. My word does not mean a thing.
It
I am a
does.
retired Air Force veteran. My wife is a retired Air Force veteran. I've been out there for 30 years, and I feel like I'm being treated like crap. And what you said makes me feel like I'm being treated like crap. My neighbor makes me feel like I'm being treated like crap, and I can't object to it. I don't have anybody backing me other than 6 neighbors.
Thank you. If there are any commercial activities, things of that nature going on the property, that can be addressed by code enforcement. But in terms of the medical hardship exemption, I think it's incumbent upon this board to recognize that when it exists. Commissioner Peach?
Just a question, with your approval, are you saying he has to submit the site plan too to make sure it's set in the right place, or are we just, because it doesn't say he's got that site plan or he's meeting the setback requirements. If we approve the appeal, he would still have to.
We can work with the applicant to make sure he has a site plan on file. Yes, sir.
He would have to have a site plan on file. Yes.
Okay.
Mr. Chairman, if I might.
Commissioner Copeland?
Sean, when you're working on that, remind him that we've gone from code compliance to code enforcement, please.
The last time I was in and talked to Danny, I gave Danny all that information. Matter of fact, I had emailed it to him as well.
Okay, well, we'll look for that. If we can't locate it, you're going to need to.
Okay,
To
not a
file
problem.
that. Okay. Not a problem. All right. So, Mr. Chairman, my motion would stand without objection.
All right, hearing no objection, motion passes. Next, we're going back to item number 7. Make sure I didn't skip anybody there. Okay, item number 7, 2019-R-024, project applicant HBL Properties LLC. Do we have the applicant here tonight, or representative? Hey, good evening. Just if you will, give Miss Amanda your name and address for the record.
Paul Salter, 6156 Enfinger Road, Pace, Florida. I'm representing HBL, Mr. Harry Harris. This is back in January 2018, the board came together and we came before the board to try to go through a road vacation over on Pace Road that goes up to West Spencerfield Road. And during that time, we were successful in doing that to try to, because we recognized there was a traffic hazard there at the end of Pace Road and West Spencerfield. So Mr. Harris the county has asked him to show a plan of how the traffic would be able to go through his complex after that road closure takes place. So we've submitted that information to the county at the planning board. And with that, at the end of this development on Plant Avenue, there are 2 lots. They total about 0.6 acres. And we're asking for those 2 lots to be rezoned to HCD commercial so we can complete this last piece of the puzzle. With that, we feel like we're still with this, and I know maybe the commissioners remember this, is that when this gets approved, we also have gone through DOT to be able to get approval with them so that people off of Pace Road can access Highway 90 through Mr. Harris's development when he develops that property. So we didn't block any traffic off. We actually created something that DOT was approved of and actually was excited about because it takes away the liability there at the corner of Pace Road and West Spencerfield. So with that, that's the reason for the request, so we can finish up this last piece of the puzzle.
Thank you. Could we hear from anyone here in objection tonight first, and then we'll let you know if we have. Yes, ma'am, please come forward.
My name is Sandra Thompson. I own 3 lots that are just 2 lots away from these properties, Lot 144, 145, and 146. My brother and my dad own the properties across the street. We have a big vested interest on Plant Avenue. And, you know, I shut my business down when we had the 2 meetings about the closing of Pace Road. And I had mentioned back then that just that little snippet of when the road was initially changed to where it could only flow certain ways and the pylons were put out, and they've give up on using the pylons because it never works. Just that little change in Pace Road created a huge uptick in traffic on my road, which is Plant Avenue. And, you know, I understand you guys voted on it, and that's okay, and everybody was, you know, in favor of expanding business and revenue and all that kind of stuff. I'm not speaking anything about the other properties that are already zoned as business. This is America. You know, use your property that you bought for business, use it for business, and do just that. But the properties that are in question right now are in my neighborhood, inside the neighborhood. And it's going to cause a big problem for people that have been living there for a long time. Many of us have just mom and pop places that are not walk-up businesses. They don't generate extra traffic. If they do this, where they're going to create all these actual location where the people are rushing to get to, so it's going to be like a big business area for doing that, we're going to have a huge uptick in traffic. Nothing can be done about that. The property was commercial, fine. But if you're going to go ahead and turn in, they keep saying the missing piece of the puzzle. This property was bought at dirt cheap prices as a residential property with the hopes of a windfall of collecting big money later on down the road, with the hopes that he'd be able to go ahead and smooth the way for somebody to be able to connect all these properties that were not connected and make a huge profit. I'm not against profit. I'm not against business and everything, in no way, shape, or form. But when it's going to impact my quality of life, the safety and everything else, then it becomes a real problem. I've got a huge vested interest in the area. And I mean, just a few months back, we had a school bus that crashed right there at the Highway 90 at West Spencer Field. That area, under current traffic, if we just look at the numbers alone, and I submitted a couple of letters, if y'all have those, but if you just look at the numbers alone of what we currently have there right now, we have a duplex that might have 2 to 4 cars at any given time on that road. There is a warehouse shop kind of thing that's been rented out, used as a business, and occasionally it's had 6 to 10 cars out there, and it, you know, but that's fine, live and let live. But and it's vacant now, so it's no traffic at all being generated from that warehouse or shop, shed, whatever they want to call it. So 2 to 4 cars is what's being generated right now, with the old flea market being abandoned, no businesses being added at all. We are having huge trouble on Plant Avenue with people flying through there. I can't count the times. I just about got wiped out again yesterday coming out of my driveway. I've got a big old crash spot about this big in my beautiful metal fence, privacy fence that I put up, and everything within probably a couple of months of us putting it up, because somebody was making a big, fast U-ey and went right off the road into our privacy fence. And everything. The day I came up for the last meeting that y'all had in regards to Pace Road closure, that day I actually come by on Plant Avenue where it connects to West Spencer Field, and the stop sign is lying on the ground where somebody had plowed right through it that very morning. It's a very dangerous area already, with 2 to 4 cars going through that area. And now we're going to open up a whole bunch of businesses. Nothing that can be done about that. That's fine, well, and good. But to take the 2 properties that are inside the residential neighborhood, that's a whole different thing. Now you're bringing the actual parking and everything right up into the neighborhood and everything. So it's going to be a noise problem. They're going to take down these big oaks. We learned after we had Hurricane Ivan just how precious those oaks are for all that traffic we get in that area. They are great insulation When you take them things down and you lose a bunch of those branches and trees and everything else, the volume goes up dramatically, okay? We've got nothing but big oaks. It was Bostic oak flea markets or whatever it was, the big oak flea markets. All them oak trees and everything else are going to come out. The noise level is going to go up huge over there. But we already have an existing problem with the traffic. I understand y'all want to put in an extra lane there on West Spencer Field. That's been needed for some time, but that's not going to fix the problem. If we're going to make it a destination for people to come to, when we're only being hardly able to handle what's going on right now, and 2 to 3 cars is being generated over there right now, and then we're going to put hundreds of cars through there. It doesn't matter if you add lanes on West Spencer Field, it's not going to make a difference as far as safety and getting out on the roads. You can barely get out. People that visit Winn-Dixie, people that go to Emmanuel Baptist Church, people that go to SS Dixon Primary, Hardee's, all these places, everybody that does business, works, go to school, walks, kids, pets, it's going to be a huge problem. We already have a problem, and it's going to make it huge because people run our road as it is just to beat the light. With those numbers at all, it doesn't make sense to turn part of the neighborhood into a business just so somebody else can make a huge profit off of something that they got for pert near nothing and then come in here and sell it off to make huge money. We already have the problems with the traffic and everything, like I said, and it's going to go through the roof even more.
Ms. Thompson, I'm just going to ask you to try to wrap it up. We don't have the timer tonight because Mark Murray's not there, but we're pushing 5 minutes now.
I've been a taxpayer over here on these properties for almost 30 years.
Right.
And I have a right to peaceful enjoyment of my property. My husband built a 60-foot porch so he could sit out there and enjoy and everything. It's already hard to enjoy with the traffic that's buzzing through there now with the changes that's already been made. When you add to it the loudness and everything that's going to happen, along with the huge uptick in traffic, it's not going to be enjoyable for outdoor living at all. You know, you've got, we already mentioned last time that we're in desperate need of having 2 speed bumps on that road as it is right now.
Right.
Nothing's been done. There's never been any speed bumps put over there. And that needs to be done regardless of whether this is or isn't rezoned. But, you know, the only person that stands to benefit from this, the county, if you expand this, they're not really going to gain a whole bunch. All that over there is already business. Y'all,
Right.
They can develop that. They can do everything they want to with that. And we still get all the county revenue from that, taxes, profits, everything else. He gets to line his pocket a little bit. That's golden. Y'all can still collect taxes as a residential on those other 2 properties and everything. But it's not fair to take hardworking people that are out here that's been living in this little subdivision for all these years and turn our life upside down with making it a huge safety issue and enjoyment issue. And all the stuff that goes on over there at Winn-Dixie Plaza, I mean, I've lived there for almost 30 years. I know that stuff goes on. The cops are out there all the time for loitering, and that's going to come right up in my neighborhood now if they put a big parking lot there in my neighborhood. Thank you.
All right, thank you. All right, quick question from Mr. Salter. I'll follow up. Would, and I don't know if you're authorized to speak on this, but would the developer have a problem with if this, first question, isn't this the same site plan that was submitted to us last year?
It is.
Or has it changed?
No, it's the same.
So this is what we approved about a year ago, but I guess we found out that it couldn't.
Right, with the 2 lots being,
Okay, I mean, it just looks the same. I haven't seen it since
It
last year,
is.
but would y'all have a problem? I know our own code says we can't put speed bumps on one road if it affects and diverts traffic, but in this case being unique, I can see that more cars would be coming in than is currently coming and potentially leave to turn west on Plant Avenue. Would the developer have a problem with funding maybe 3 speed bumps on Plant Avenue west of that, so where it would sort of alleviate those concerns about increased traffic on Plant? It would at least make it a little bit more cumbersome to help motivate people not to use Plant as a cut through.
well, and I think we're not interested in having people come through there at a high rate of speed. I mean, we're going to be trying to operate, you know, a business of some sort there. So, we don't want people to use that as a cut through. So I'm sure there would be
Well, I
some
mean,
opportunity.
on the road itself, not in your, I wouldn't want to have it in, but I'm talking about whereas the traffic increases, the turnout on Plant, so that if somebody wants to go west, I would like to encourage them to go through via Highway 90 or West Spencerfield. And I think if we did have some speed bumps on Plant, even if it was 2 or 3, depending on the length of Plant Avenue there, I think that would discourage that. And I think that would mitigate the concerns. I mean, I've got letters here tonight from some of the surrounding property owners in favor and some
Right.
in opposition. And I think that the majority of what I hear in opposition could be mitigated if the developer would be willing to put in a couple speed bumps to deter increased traffic through Plant Avenue. And I think that would be, personally, I think that would be fine with our code, because we're not trying to push traffic to another road. We're trying to keep it to where it's residential traffic.
I think I'd like to ask Mr. Harris
Okay.
if
And Dan or Roy, as he does that, Sean may know, I know Stephen's not here. Do you know roughly what the cost is running that we spend on speed bumps? I think maybe, yeah, so I'm not sure. I mean, I can't
Yeah.
imagine it would be tremendous. It's an asphalt hump, but maybe a couple $1,000 at the most. I mean, it seems like I've seen a figure that said maybe 2,000 or something, but, and I'd be fine if you want to ask me. I just think that that's a way that we could truly try to preserve the residential atmosphere of that road. I could see.
let me speak to Mr. Harris just a second.
Okay. Now, while he's gone, do any other members of the board have any questions or comments?
Mr. Chairman.
Commissioner Cole.
You're right on target. That's kind of what I was thinking along those lines to help Ms. Thompson out. And since we don't know a price, you may just say traffic calming on Plant Road, an aid with traffic calming on Plant Road up to $5,000 or $6,000. I mean, if Roy's not giving me a big no-no, so.
If you will, let me just hear back from him, and then we'll circle back. Yes, sir.
I think if, I don't want to say yes, and then I mean, we're okay with it, but at the same time, we'd have to look at some prices as far as what those speed bumps would cost. For thinking maybe a couple $1,000s each, maybe. I mean, we're willing to do that, to work with the county. We want to be good neighbors for certain when we do this. I would like to make a point here that, we get up here and we talk about this, we think this is all residential. But Ms. Thompson's running a business too on Plant Avenue, and she's creating some of the traffic coming out of there. So I just want to make a point that not everything up and down that street is just residential houses. So we're okay with the speed bumps, but we're trying to make, our development is going to be a nice development. This development that we proposed is, it's just a preliminary drawing that we're trying to get to the next step.
I'll say this, I feel like I've seen numbers somewhere that was $2,000 and some odd dollars for speed bumps to be installed. I feel extremely confident that I've seen that somewhere. So I tell you what, I'll sort of meet in the middle. I think what you're going to do will be a phenomenal improvement over what is currently there. Have no doubt, that's why the board voted for that. But really, even more so than Ms. Thompson or anything, I just pictured, I don't know if there's young families living out there or not. But if there was, and we could deter increased traffic from Plant until that did further develop, I'm sure as it will eventually, to more commercial
Right,
down the Years
right.
Road. But I would like to know that if I approved it, we did mitigate what I think we could all say would probably be increased on Plant. We could at least mitigate it to where they're not going down into the residential. So if the developer would agree to work with Public Works under a Public Works' suggestion or whatever we got to do to cover the placement, to put 2 speed bumps, I think 3 would work. I know Plant's not real long though, but if you could do just 2,
Right.
I think if you would agree to that and work with Public Works as far as the ideal placement on the road and cover the cost of that, then I, in good conscience, could say, I think this is a great plan. I think it's a lot better than what we have there. I mean, clearly the eyesore of the dilapidated flea market. And I would also know that I think we've taken true steps. I mean, speed bumps have been proven to deter traffic from going through the residential area, because
Okay.
that's definitely not. So if you feel comfortable with that, I think, to me, it would be as close to a win-win-win as we could possibly
So
get.
we would agree to that.
Okay.
Yes.
All right. Ms. Thompson, do you have any last remarks? And I definitely am not trying to be short with you, but I'm going to have to move this item and then leave so that I'm not
My
late,
dad's
but-
in the hospital,
I-
so
I
I'm in a hurry
understand.
too. But, you know, I haven't tried to hide that I have a business there.
Right.
I've said repeatedly, we have a mom and pop, but we are not a walk-up company. People do not come to my house. It's my home and office, and they do not come. I deal with everybody on the phone. So I do not generate extra traffic for people coming and gathering at my place as a business. Most people that have mom and pop places over there do not have. The beauty salon that's over there on Pace Road, obviously, has walk-up. But that's mostly it for walk-up business. Most people do their business actually over the phone. It's not creating extra traffic. As far as the speed bumps go, you know, as far as I'm concerned, the county should be responsible for putting speed bumps over there, because it's been a danger thing for a long time and everything. But what I'm saying is it's not going to fix, even by, they need to be there regardless right now, without all the extra traffic that's about to come through. They already need to be there. And it's disingenuous to say to curtail Pace Road from being a skip-through road, because they're creating a parking area where you actually enter into the business by accessing it from Plant Avenue. It's a place to where they go on Plant Avenue to get to that business. So it's definitely going to increase the traffic.
Okay. Do you have anything new? I mean, I would hope you would think that's at least a step in the right direction. I mean, you're saying you feel like speed bumps are needed.
I
and-
mean, you know, we've got how many people that wind up dead and crashed and infirmed all the time from this area already being so congested.
Trying to sort out of a compromise, but if you don't have anything new, then I appreciate it. I respect your comments, and I think you can clearly see I am trying to work on a compromise.
I'm not against any part of that being done. I'm just
Right.
against the part of it coming into the neighborhood portion and using it as an access to get to that, and there's no way, that what they're by their own plans, they're putting
Right.
in here, you access it from.
I see that, and that's why I'm gonna, they're agreeing, we're gonna have 2 speed bumps that'll both be located west of their development on Plant Avenue, and that'll hopefully curtail any of that traffic from passing the development or leaving out. And I'll share with you as I do, and I don't mean this disingenuously, these gentlemen here that wear these green uniforms and work for our phenomenal sheriff, their job, they are charged with enforcing the laws of the county. And so I can't put speed bumps on every road. It would be, the unfortunate thing is we have citizens that are lawbreakers, and I would just encourage you, please reach out to our sheriff. And I know these gentlemen do a phenomenal job in trying to get there with what the resources they have. And if you see speeders, don't hesitate to call them, let them get a mobile radar unit or whatever. But I think these speed bumps will help with that. So,
Well, it'll help for the speed of my road. It's not going to help anything at all with
Right.
all the congestion that we had. I waited
I
5 minutes to
understand.
get from Winn-Dixie parking lot to my road, which is directly across the street, with what we already have over there. So it's going to make something hugely wrong over there. But thank you for hearing.
yes, ma'am. All right, I appreciate the comments. With that, I'll make a motion, I'll do so without objection, that we approve the request for rezoning contingent upon the developer's willingness to put in 2 speed bumps that will be located on Plant Avenue to the west of that entrance, and they'll coordinate that location with our Public Works Department. Commissioner Cole?
I'd feel better, and probably Mr. Harrison, Mr. Salter would too, if you, since we don't know an amount, put some sort of cap on it,
right.
$5,000, $6,000.
I think, I
Pretty
think to
much
be,
upper end.
I think to
Mr.
be safe,
Mr. Chairman, looking at a memo that was sent to the Board of County Commissioners in 2018, the price of a speed table is between $5,000 to $7,000 apiece.
yeah, not a table, just a speed bump.
Yes, sir.
I'm not asking them to put a table in. Yeah, a lot more significant. I'll say we'll make a cap of 7,000. I think it'll be less than 6, but just to be safe so that we can cover. And I think the spirit of it, I appreciate what y'all are doing with the developing it, and I think that's the safest way that we can sort of mitigate that damage. So I'll make that motion without objection. All right, hearing so, it's approved. Thank you all for coming. Thank you, Ms. Thompson. All right, the next and last item on the agenda, and I'm going to have to turn it over, Commissioner Cole is going to take over my role as chairman for the remainder of the meeting, and that'll be the administrative appeal for the floodplain administrator's decision. Commissioner, can we take a 5-minute break before that starts, please, and we'll reconvene, let's say we'll reconvene right at 7 o'clock. All right, sorry. That's as much compromise as you can expect. All right.
So it's, we're pushing. We still don't have yeah.
Because we have a lot of people that, I say a lot, that we have people in our county that want to do some of the data, change their, what I found remarkable is some of the data that was showing what their survival is if the elevations were actually dropping.
Modernization. There are a couple things that go into it. Some of it's kind of, a redefinition of having itself. Some of it's but for the most part, we're seeing decreases in kind of the bay and trees. And it's still most of kind of ocean. Most of the trees stay still.
Yeah, right here. Yeah, right here.
The elevation's going up, it's certainly a big concern for people. That's what happens.
Now, do you ever attend their state flood manager conferences through associations of state flood managers?
I did read one. That was a Ford's Beach. Back in October, I spoke.
The only one that I've been in as far as, the only one that I've national was held in Biloxi. And it was 2004, right before Hurricane Ivan. So actually, really, it's about the time that they first came out with that RSD program where jurisdictions were using and so
I guess the national actually just ended that.
All right, we'll go ahead and get started. We have this evening, give me just a second to get caught up here.
Mr. Chairman, let me open up the proceedings.
Good idea, thank you.
Okay. We're here tonight on an administrative appeal of the determination that was made by the floodplain administrator, building official, in regard to the interpretation of our floodplain ordinance, our land development regulations, specifically having to do with a structure that's been erected in the floodplain. The first we'll offer into or place in the record on the appeal the voluminous documents that have been submitted by Mr. Mead, by Mr. Hoffman, and by myself and the staff in regard to this issue. The issue is whether or not the applicant for the permit submitted sufficient engineering information to adequately demonstrate that the structure would not cause adverse effects on adjacent properties. There have been a number of floodplain analysis, wave analysis have been submitted. They've been reviewed by the floodplain administrator, and she's here to testify as to the basis for her determination. The applicable Land Development Code regulation, which is 10.06.02, says the Santa Rosa County Board of County Commissioners shall hear and decide appeals when it's alleged there's an error in any requirement, decision, or determination made by the floodplain administrator and the administration and enforcement of this ordinance. There was when the determination was made that there was a violation, there were notices of violations that were submitted to the subject property owners. There was a special magistrate proceeding that was instituted at the request of the applicants, and during that proceeding there was a request based upon our special magistrate code enforcement ordinance, which says a special magistrate shall postpone and shall not conduct a hearing if the named violator, prior to the scheduled hearing date, files with the County Board of Adjustments an administrative appeal concerning the interpretation or application of any technical provisions of the code section allegedly violated. However, once an issue has been determined by a special magistrate in a specific case, that issue may not be further reviewed by a county board in that specific case. A named violator waives his right to an administrative appeal to other boards if the violator does not apply for such an appeal prior to the violator's code enforcement hearing before the special magistrate. I read that to you because there are a couple of issues that Mr. Mead, I think, is want to put in the record as an objection. One being that the appeal is going to the Board of County Commissioners as is required by our land development regulations and not to the Board of Adjustment. And the reason for that is, number one, our Board of Adjustment, we do not have a Board of Adjustment that deals with appeals of the Florida Building Code. The language in that provision of the statute applies to an appeal of any other county boards, which is the reason that it's going today to the county commission as opposed to another board. And, well, that's the first issue in regard to it. The procedure that we will have is that the building official, floodplain administrator will make the board aware of the basis for her determination. The board can then decide whether there's competent substantial evidence to support her determination or not. Mr. Mead has some objections that he wants to place in the record, or some statements that he might want to make.
Thank you. I will thank the county attorney. I think he made an adequate recitation of the postural facts as we stand here. And with regard to the nature of the appeal, it is the fact that those issues would be waived that is the primary reason why we brought this appeal. We did not want to go forward and cut off any possibility of review of the serious technical questions that have to be addressed and which have then legal and constitutional ramifications because of due process questions. Leaving that aside, I do have some formal objections to 2 points the county attorney has raised. One is the taking of testimony in this proceeding as an administrative appeal. We don't believe that's appropriate. We have put forward a documentary record of the proceedings and the issues, which are documentary purely. And I don't think it's appropriate to take testimony to supplement or to change the record at this juncture. Obviously, that's a matter for the board to take up and decide, but that is, we want to make sure that we have a record on that because we think it's important. Secondly, I will maintain a further objection with regard to any matters submitted by Mr. Hoffman's clients and him on their behalf, simply because they intervened in the special master proceeding, which is something I've never heard of before. We objected below. We were overruled. I expect, quite frankly, that the board will go forward in the same posture, and that's fine. But as for the record, I continue that objection to the participation as a party to this appeal of people who are not subject to, not property owners, not subject to the permit, not subject to the violation. And I'll leave that at that. And with the board's permission, after you address those objections, I'll be happy to proceed.
Right, Roy, we need Rhonda to,
Yes.
May I speak on the procedural issues for the intervention?
Mr. Hoffman's clients or adjacent property owners, they were allowed to be interveners, limited interveners at least, in the special magistrate proceeding, and I think it's appropriate for him to speak on their behalf tonight.
noting that, then you have the mic.
Thank you. I'm only going to address the procedure issues at this point, but at the end of the day, my client is in favor of what the county is seeking to do to enforce the permit. The problem I have with, though, is the approach we're now taking, I'm concerned has the potential for a lot of delay. If we go the route of doing testimony, because if you read those pleadings right now, what's been appealed, exactly what the issue is, it's hard to tell. And I want to note one significant issue because the notice of appeal references Santa Rosa County Code 2-313. And the county attorney has stated that we're going to go under the Land Development Code. Problem is, that's not what's in the notice of appeal. The notice of appeal says it's going to go under the Santa Rosa Code. You need to know which issue we're appealing on, because what's going to happen is, if you make a ruling and you consider evidence, when it's not clear what evidence there's going to be, I don't have any doubt he's going to file something in circuit court seeking certiorari review. And what will happen is, if that court determines we've got a problem, then we're going to be going back to square one. And just to be clear what square one is for my client, there's a 6-foot wall that an engineer is saying will create a magnification of 2 times for the wave height.
Mr. Chairman, I thought he was going to stick to the...
Well, the reason is time. I think we can agree that time is of the essence, and we need a ruling. And if we go back to the special magistrate, you have a forum where all the evidence can be considered. I'm concerned if we go the procedural route when it's not even clear which appellate provision we're going under. Are we going under the county code that was cited in the notice of appeal, or are we going under the one in the land development code? Because I understand exactly what the county attorney's saying when he says there isn't a value adjustment board, meaning there's problems on what's been appealed. But you can't just automatically switch to another land development code. Because when you take that into circuit court and you review it under a legal standard, you're going to have problems. And at the end of the day, I feel like we're going to be going back to the special magistrate. Those procedural issues need to be worked through. Because right now, we've got a problem on how those are being presented, and my primary concern is the interest of delay.
I appreciate Mr. Hoffman's position. The notice administrative of appeal 2-313N6 is the language that I just read to you, which is codified out of our code enforcement section. So it is based upon that, but it also provides specifically that that it recited 10.0912, 10.0915, 10.1307, 10.1308, and the requisite and the comparable provisions of the Florida building code. So I don't think that there's any mystery on the part of the building administrator or the floodplain administrator, building official, as to what the basis of her determination was, and that it was that basis is being challenged tonight. And for this board to hear and decide that, they need to hear what her basis is.
If I may, Mr. Chairman.
Thank you, Mr. Andrews.
I would ask that I be allowed to frame the issues for appeal before we hear the response, because I would deem that to be a response, and I think in fairness, we should be allowed to frame the issues for appeal that we're here on. I would note in response specifically to Mr. Hoffman's representation that if you read the brief we prepared for you, we've cited the provisions that says that the two sections of violation, one is a building code section, one is a floodplain administration section, and the law says clearly they're to be read together and they're to be applied together. So I don't think there's any mystery about that. The only problem here, and the only reason why we're here at this otherwise possibly premature moment, is we would waive these rights of addressing these technical questions which have these other ramifications, and I simply can't allow that to happen for my clients without having it heard. So I'd ask your leave to proceed, if I may.
Pardon?
I would ask your leave to proceed, if I may.
Mr. Chairman.
Hang on just a second there. I'm going to recognize Commissioner Lyncher, please.
Thank you, Mr. Chairman. I just wanted to say at the outset, this is a quasi-judicial hearing. I have spoken with Mr. Fairbanks back in 2017. He called me about the issue. I met with him early October 2017. Have not spoken with him again since that date. I was out there, I don't believe. I know I haven't spoken with you since October of 2017. I don't. Yeah, but it was still in 2017, wasn't it? Yeah, I think it was 2017. Yeah. So just, and the notice of administrative appeal, correct me if I'm wrong, the notice of administrative appeal is directed to the determination of the code enforcement official, Rhonda Royals, as to the technical interpretation and application of the substantive content of technical evidence sufficient for, or the waive analysis demanded by code enforcement official. So that's the root of the appeal, right?
That is precisely yes.
Thank you.
All right.
And Mr. Hoffman, did you have an objection? Was your concern related to that issue at this stage?
It is. But one point I'm not sure everyone understands. This case has already been sent to a special magistrate. A 19-page motion to dismiss was filed. The county responded. There was a hearing by the special magistrate that denied their motion. And then at that point, this appeal filed. So procedurally, we're at a point where a motion to dismiss has been denied, but you're appealing midway through. There hasn't been an evidentiary determination. So there is already currently going a special magistrate proceedings, and I don't see a clear answer on what happens to that case based on what's happening here today.
All right, give me just a moment. Mr. Andrews, I'm going to need some help with this because unfortunately I'm an auto mechanic, not a lawyer, so I need, if you feel like we need to, this board needs to hear first from Ms. Royals, or do we need to continue down the path we're going?
Well, I think that Mr. Mead has put his objections on the record. I think that the posture at this point would be Ms. Royals' testimony, his response.
With respect, I think I'm entitled precisely to raise and describe for you the issues of what is in the notice of appeal so that you understand our position.
I understand your position, but this man here is hired to protect this board, and I'm going to follow his suit.
I understand that. He's also prosecuting this case, and so I'm mindful that, that's a difficult situation for any lawyer to be in. I've stood on several boards and represented other municipalities, but the fact of the matter is, I think we should, in fairness, be allowed to frame the issues here before we have a response from a county official whose decision we're appealing. That's the reverse of the normal mode of proceeding, which is we get to make our case and she gets to defend her actions. I simply ask that we had to proceed with ordinary precedents in that regard, that's all.
All right, give me just a second. Mr. Andrews, let me up here.
I don't have a problem with him, but Mr. Mead's comments are not evidence. It's an argument. I don't have a problem with him arguing what he thinks his case is.
That's fine.
Okay.
That's fine.
All right, and my statement earlier, I didn't want to belittle myself as an auto mechanic, but you guys talk a whole lot faster than I can understand, so slow it down a little bit. And I got an engineer over here, he may be in the same boat I'm in, so you guys know what you're talking about when you start all this legal jargon, so help me out a little bit, make it a little simpler on at least myself, and Dave's over there smiling, keeping quiet, so.
I had lawyers work for me.
Okay, thank you. Thank you. All right, proceed, but remember, you're not talking to another attorney.
I'm well advised, thank you, Mr.
Thank you.
Chairman. So the big question is, and I think Commissioner Lynchard has identified it, is why are we here? Okay, we're here because if we don't bring this issue forward now, we waive the question of the technical standards to be applied if we go forward in the proceeding. That's why we're here. And the problem and the substantive reason why we're here is we have been struggling to identify what the standard is that we're supposed to go through the hearing to determine. That's the nugget of the problem here. Now, what the code says, the code section that has been cited in the violation, is that we have to provide evidence that shows that the construction that is to be done under the permit is not likely to create damage to adjacent structures in substance. And this, in provisions of the Florida Building Code, it addresses the ASCE provisions, which say that that is normally done with wave analysis prepared by a qualified design professional that will show those things, okay? And the record of this permit that went forward, which you have in the binder that was supplied to you, is precisely that, a permit that was approved with a wave analysis applied by Mr. John Elamont, P.E., who is a qualified design professional and whose work has been accepted, as you'll see in Attachment 9, on numerous occasions using the exact same standard for similar structures by the county and permits issued thereon since 2013. And of course, there are a number of other engineers that have supplied similar wave analyses, although on very different bases and sometimes. Some of them are based on FEMA standards, some of them are based on U.S. Army Corps standards, some of them are based on other standards. And all of those standards have been approved in various permits by the building official and floodplain administrator. There is no rule in the county code, there is no rule in the Florida Building Code that we've been able to identify or that the county has brought to our attention in their efforts, or in the floodplain statute or any regulations issued thereunder, that says what the substance of the quantitatively adequate, close quote, which is the supposed violation pertaining to that wave analysis. What is quantitatively adequate in that wave analysis? That's the reason we were violated, according to the violation, is that what was submitted was not quantitatively adequate. Well, that raises the question, it's not enough. Okay, we get that. It's not sufficient, I think, was the language that Mr. Andrews said. Well, what defines how much is enough? Where is the rule, the measure for the quantity or the sufficiency? And it simply isn't there. All we have is a provision that says evidence, and evidence in the form of an opinion is perfectly admissible, and that's been cited in the brief. There's nothing in the law of evidence that says what that standard or measure should be. In fact, the law of evidence says that an expert opinion need not supply the backup information that underlies his opinion in order for his opinion to be admissible as evidence. So under those circumstances, it is incumbent upon the administrator in that setting to either issue authoritative interpretations in advance that my client can then rely upon, saying, what do we need to include? What content needs to be in such a wave analysis to pass muster under those standards as an exercise of reasonable discretion in terms of her review of that. And I don't deny that in some of these settings, as you have and often in professional and design settings, there is a realm for some reasonable discretion, but it is not an arbitrary discretion. It has to be confined by some reasonable or intelligible standards. Now, we have a record, in fact. We look back at the record of those other permits precisely to decide, okay, well, I'm a common lawyer. we look to precedent, and you can establish standards by precedent. Is there anything that we can look in those standards that would tell us what that would be? And again, we can't find it. In fact, we found that Mr. Elamad's opinion in a very similar form had been approved in a number of different cases back to 2013. And others on differing standards had also been approved back that far. And with that, we could not even establish any precedential basis in terms of the exercise of that discretion over time that would frame what it is we're supposed to prove in that special master hearing. And that's the reason why we're here. The other reason, in terms of what flows from that, is what does that mean? Well, that's a due process problem, because if you don't have a standard you're supposed to meet, and someone is telling you you haven't met our standard, that is the definition of what we call an arbitrary and capricious decision. That's unconstitutional. If you have a provision of law which doesn't establish a standard and you're going to enforce on somebody with that quote-unquote standard, that is what we call a vague statute or provision. And such a provision is deemed void. It can be void on its face, or in this instance, I would say, void as applied. I think that Ms. Royals is entitled to certain discretion in terms of exercising her authority with regard to the statutes that she has in the form that they presently exist. I think she is perfectly entitled and perfectly empowered to issue authoritative interpretations saying, I want a waive analysis to comply with the following requirements. I want these things attached so that I can review them. In fact, one of the exhibits that we supplied to you, the letter from the Florida Division of Emergency Management, describes some of the things that they would prefer that the county be looking at and hire an engineering professional with the appropriate background to review those before issuing the permits. Got no problem with that on a prospective basis. What we have a problem with is the fact that my clients, with the existing history of issuance of permits on precisely the same basis, submitted their permit, not only submitted their permit, but revised their permit and had the revision approved to move it further back off the water, which should ostensibly reduce these concerns. That was also approved, and then they commenced construction to the tune, as my client's affidavit shows, of $97,000 plus dollars by the time the stop work order was issued. Understand, we don't complain about the stop work order per se. We think once Ms. Royals got the phone call from the division, got the letter describing their concerns, she had legitimate reason to say, hey, let's hold up a minute, let's look at what we're doing, and that's fine. What we object to is that there has been no response to our entreaties to say, well, what can we do going forward with the work in place to meet any reasonable concerns that you can define for us that don't unduly increase the cost of the project? The response has been notice of violation, tear the whole thing out, start over. That's why we're here. And that creates an issue we call estoppel. Because a permit was issued, it was relied upon, and I'm going to address a couple of points of law that Mr. Andrews has addressed, because I think his cases actually help our position. I've cited a number of those similar provisions in our brief, and you can read those at your leisure. The cases that he cites, I think one of them has a wonderful quote which says, stripped, this is the Town of Largo versus Imperial Homes, it's a 1975 case, and it says, quote, stripped of the legal jargon, which lawyers and judges have obfuscated it, the theory of estoppel amounts to nothing more than an application of the rules of fair play. One party will not be permitted to invite another onto a welcome mat and then be permitted to snatch the mat away to the detriment of the party induced or permitted to stand thereon. A citizen is entitled to rely on the assurances and commitments of a zoning authority in that case, and if he does, the zoning authority is bound by its representations, whether they be in the form of words or deeds. Close quote. That's the issue. That is precisely the issue. Now, Mr. Andrews has said, well, there's case law that says out there if there's a mistake of law or a mistake of fact, well, that may not apply. The cases he addresses, I'm going to specifically touch on. Godson v. Town of Surfside. That was a mistake of fact because they had an express provision that there was a 40-foot buffer from the ocean in terms of the building they were trying to build, and they violated it. It was written in the code. You can't build any closer than 40 feet to the Atlantic Ocean. And they violated it. And they said, you can't rely on something that is a facial violation of the code because there's a written standard and you're held to know what the written standard is. No objection to that principle of law, but that's not this case. Town of Lauderdale by the Sea versus Moretsky, that's a 2000 case. In that case, the person who had obtained the permit built in the right-of-way. Well, you can't build in the right-of-way. It's illegal. There's clear law on the point, not only in the ordinance, but in state law. And he attempted to establish an estoppel saying, I get to build on the right-of-way because you approved my permit. Well, no, that was a mistake of fact because they didn't know where the structure was actually located. That's a mistake of fact that we thought we could approve a permit for this structure in a location. This is not the location that we thought we were approving. It was in fact in the right-of-way, which can't be done. That is both a mistake of fact and a mistake of law because had they known that it was in the right-of-way, they never would have approved it because that's illegal. Lastly, the City of Miami Beach versus Meiselman was a sign ordinance provision. They put up a sign that was 437 square feet large above their building. They could only put up one that was 224 square feet, and that was written in their code. Well, that's a mistake of law and a mistake of fact if they approved it knowing that. But the fact of the matter is you cannot have an express provision, violate the express provision in the law, and expect to get a estoppel. But where you have an exercise of discretion as here, even if it's reasonable, if that discretion is exercised, even if in error, and they would prefer that they had made some other decision later on, they can't go back after you have relied upon that, spend a bunch of money on a permitted project in compliance with the permit, and say, no, 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 we're going to violate you, we're going to revoke your permit. Oh, by the way, we didn't get a hearing on that. And we're going to violate you at the same time, even though you built it under the permit that we issued, and spent a heck of a lot of money doing that. Now, that is the quintessential estoppel under our case law. And lastly, in a case cited by Mr. Andrews, is in the Town of Largo Imperial Homes case. I want to just draw this to your attention in closing, is what the court said there. He said, the court held that the builder had a right to rely on the actions of the current government body, regardless of the existence of public protests. Now, Mr. Hoffman's clients have been very active in expressing their protests over whatever it is that's done on my client's property. In fact, if you read the letter from the Division of Emergency Management, you'll see that what instigated the interest of the division was, in fact, Mr. Fairbanks speaking to the gentleman who wrote the letter that instituted that phone call to Ms. Royals that resulted in the stop work order and then the later letter documenting those concerns. But the court goes on in that case, and it says, in essence, the town has asked us to rectify what it now considers to have been, quote, mistake, it's quotes, not mine, made by its earlier commission and perpetuated thereafter. This we cannot do. The record amply supports the findings of the trial court, resulting in estoppel against the town. Under these circumstances, if this goes forward, my clients are going to have to spend all of the money to attend a hearing, defending their case on standards that nobody can tell them, with parties objecting that we don't know why they have a right to do that when the county is sitting here to enforce its code. And all they did was go to the county, submit what the county required, get a permit, build according to the permit, and now they're told they're going to have to take it all out again. And they didn't do anything wrong. And they've not been told any substantive standard as to what would be adequate to meet those requirements, not before the permit was issued and not in this proceeding. And because they have not been able to tell us what that technical standard is, we can't go forward in this proceeding, and that's the reason why we're here. And we would ask that you acknowledge the record before you that there is no such standard, and as such, no proceeding can go forward. And the county should recognize the estoppel here, and the commission should simply stop this proceeding, allow reasonable discussion about what can be done with the work in place from that point forward between the building official, which my clients don't object to, but to try to tell them that they're going to have to tear out their whole wall as a result of this procedural morass and the lack of defined standards being applied after the fact. Oh, by the way, that's another constitutional violation. We don't change rules after the fact in this country. That's a problem. Plus, we also have, remind you, we have all of these other permits issued on the same basic form of standard not adequately quantified, as far as I can tell, if you use what Mr. Elliman's opinion is, and the form of his opinion as it was delivered. The others are no more sufficient in that regard. Are we going to have an equal protection issue there because none of those people are being violated? There's a whole kettle of problems created by this that can be solved by simply saying, you told the people they could go forward, they went forward, you stopped them at a certain point, fine, good on you, figure out how to go forward from here. Don't try to go back and fix the county's mistake, the county's error in applying its code without an applicable or adequately defined provision, and make my clients pay for it. That's not right. That's grounds for estoppel. It is grounds for you all to exercise your oversight capacity in this appeal and let things go forward from where it stands with the work in place and not with what has been proposed in this proceeding. Thank you.
All right. Mr. Hoffman, right now, the way I look at this portion of this is between the county and the applicant for the permit. You, from what I understand, represent neighbors that don't like the seawall. Am I correct?
You are correct, but not on the procedure posture.
Okay.
Normally.
All right. So what I want to do is divide this into two things. I want to hear what the county's position is as to why we stopped this project from my staff's analysis. I've heard the applicant's side of it, and then I'll hear the neighbor's side of it. And if I have any objections or any other suggestion from my board members.
Well, right now, an order's been entered by the special magistrate determining us to be an interested party. He just gave the equivalent of an opening statement. I would merely ask for the ability to make an opening statement before you go down the path you're discussing going. I think it would help frame the issues. Because right now, if I'm on the board, unless the three of you have studied those documents intensively, it's kind of hard to figure out what's going on.
It was just on my desk today, so absolutely have
then
not had time.
I'm going to take the advice you just gave and eliminate the legal jargon and give you a picture of what's going on.
All right, give me just a second. I'm going to reach out to fellow board members. Which direction?
That's fine.
Okay. All right, Mr. Hoffman, proceed.
I'm going to give you some information on the facts, but I'm also going to tell you the ones that are in dispute. I'm not going to argue as though this is what it is or isn't what it is, because some of these facts haven't been determined by the special magistrate. What's at issue is you have two lots on Santa Rosa Sound. A retention wall has been built that's about 6 feet high and it's just off the water. The problem is, and this is based upon an engineering report the Fairbanks have obtained. So Mr. Mead's clients may dispute what this engineering report says, but what it states is that this wall will divert waves by a factor of 2. It will erode the vertical property line by up to 4 feet. It will create 50% more water retention. Those are the reasons and the actual problems that we are dealing with. As far as some of the legal issues that are in play, the problem is the lot that the Vorshaken own is in a coastal flood zone area, and in order to build that wall, structural fill dirt has been put in, and that is not allowed under the code. And they may have an argument as to why that occurred, but that's the issue that precipitated this appeal. Now, what happened is, and there was a long history for 2 years. Let me summarize what Mr. Mead basically said is, they issued us a permit, and then later, they issued a violation, and we don't think that's fair. Now, there's an extensive body of law about how that's applied. What happens if you issue a permit, and then you later go forward and cite someone for a violation? The problem, though, is on October 31st of last year, the county filed a notice of violation and went down the path of code enforcement. All the parties were aware of it. It went to a special magistrate, and at that point, substantial pleadings were filed. A 19-page motion to dismiss was filed by Mr. Mead. We filed a motion to intervene because the special magistrate process is quasi-judicial, meaning members from the general public can come in. There are rules within the code that explain how the special magistrate is to consider evidence, but there's a lot of flexibility there. But it's being done by someone trained in the law, who's aware of what those code provisions are. The first hearing took place on February 12, 2019. And at that hearing, arguments were made by myself, by Mr. Andrews for the county, and by Mr. Mead. And the determination was made that the order to dismiss was denied. Now, a lot of the arguments that were presented, what the county's response was, that Mr. Mead summarized, those were the exact same issues that were addressed before the special magistrate. And the special magistrate made the determination that it's denied. Now, that doesn't mean that Mr. Mead's client cannot then move forward with the case. What it says is the county's violation notice met the basic requirements of law, meaning if you assume every single thing the county put in that violation notice as being true, which is the standard that applies, then there's enough to move forward to trial. Now, that same day, 2 days after that hearing, the special magistrate entered an order saying, this is the case management order. This is how this is going to proceed to trial. If there's any documents out, this is the window when everybody can exchange documents. This is the window when you can depose witnesses, if you need to depose witnesses, all culminating on a trial date. If someone wants to have a witness there, you have the ability to coordinate on bringing your witnesses. Members of the public can attend and make whatever arguments they want. At that point, the special magistrate would have full ability to make whatever decision he wanted on the fact that a permit had been issued and that there was now a violation. County attorney would be able to make his argument, we'd be able to make ours. And at that point, the special magistrate would make a ruling. Any party who did not feel it was favorable could come back to this board. And at that point, if that occurred, you'd have a record. You'd have something establishing what evidence there was, what facts were there, what did the witnesses testify to, what were the issues, what were the reasons that the special magistrate made the decision he did. But right now, we're shortcutting that. And the reason we're shortcutting it is a term that lawyers use called forum shopping. And that is forum shopping. What it means is you go to the first hearing, which they did, and the special magistrate didn't buy the argument that Mr. Mead just made. Because what he's effectively saying is you can't enforce that code provision. And when he did not get the ruling he wanted, at that point, he went to a new court. You three individuals are the new court. Now, the special magistrate case is still going. Problem is you did it before the first case got completed. That'd be a great thing. Every losing attorney would love that. If you lost your first motion, you just go pick a new court. That's what we're doing right now, is picking a new court. But there's a problem. And this is where our position's a little different from what both parties are arguing right now. At the end of the day, if you go the full distance and adopt what the county attorney's advocating, then you will have articulated what the technical standards are for the floodplain management provisions of Chapter 10 of the Land Development Code. Now, how the three of you are going to do that today without the assistance of county staff, without really knowing what the problem is, it's kind of hard to figure out how you're going to do it. But let's just say you do. You still have to figure out whether or not they violated it. At some point, you've got to go back to the beginning. And my clients don't have a lot of desire to see this end here, then go to circuit court to decide whether or not we've met due process, only to go back to the very beginning with the special magistrate. This case needs to go back to the special magistrate. But you also need to be clear what the stakes are. Because right now, if you do not send it back to the special magistrate to enforce the code, you got a problem that extends far beyond the litigants in this case. Right now, Chapter 10 of the Land Development Code lays out the floodplain management regulations for this county. And in this county, they're better than the minimum requirements that the flood insurance program requires. And what does that mean? What it means is that when you put regulations in place that are more favorable than what the flood insurance program requires, you get a favorable community rating, which means every premium that any citizen in this county pays for flood insurance, they get a discount because the regulations are more stringent. For example, in this case, if you say you can't put a 6-foot wall because it may knock out the property owner who's sitting next to you, that's significant from the flood insurance because they don't want to pay the casualty loss if that property gets knocked out in a flood or a hurricane. That's what we're dealing with. If you make a determination that says this county can't enforce those, not only do you jeopardize the favorable community rating, you potentially jeopardize the ability of this county to participate in the flood insurance program. And I'm not just speculating on that, because the 2 years before this thing got to the point where the county filed a violation notice, there were letters going from Steve Martin at the State Floodplain Office. There was personnel from FEMA all the way at the federal level that made observations of the same thing, that this county needs to enforce its code. And right now, you're being put in a quagmire where the county's made the effort to enforce it. And right now, the reason why the appellants, the Vorshakens that Mr. Mead is representing, don't want this to go to a trial before the special magistrate is because it's kind of hard to win. If you brought in fill dirt and packed it down on a flood zone, you really don't have much of a defense, except that the county issued a permit. Well, in all candor, shame on the county for issuing that permit. They made a mistake. But the law that applies when that occurs is very specific. That belongs in the hands of a special magistrate. You don't need a lawyer explaining that to you. That's common sense. I think the three of you know right now that having you act as a judge to consider what evidence does and does not come in, that belongs to the special magistrate. If this approach works, that means every single time someone gets an initially unfavorable ruling from the special magistrate, they're going to come before you. You're going to have your docket jammed up, basically doing the job of the special magistrate. That's not only is it inefficient, but it sets the stage of not getting a resolution. For the individuals who are near that property, they're worried about the next hurricane season coming in. And in all deference to Mr. Mead's client, they don't want to be in limbo for the next 2 years either. The only logical route this case can take is for you to make a determination that you need to go back to the special magistrate and get a ruling. It doesn't mean you can't come back in front of you, but right now we're going to hear a partial amount of evidence. I mean, what if someone from the public wanted to come in and make comment? You look how it's noted on the agenda, it's termed as an administrative appeal. I mean, most people look at the word trial as the point where someone comes in. And I'll make an interesting observation that most of the cases that were being cited to you, those were cases that came after a trial court made a ruling. The trial court, who is the special magistrate, hasn't made a ruling in this case because it's coming to you before it went to a trial. Right now, if we're going to do this in the most efficient manner, in the manner that's contemplated by the code, it needs to go back to the special magistrate. And the significant point right now is, if you read the Santa Rosa County provision 2-313, subsection N, subsection 6, which is what's on the notice of appeal, it lays out the standard that applies on appeal. And I want to read one sentence to that. However, once an issue has been determined by a special magistrate in a specific case, that issue may not be further reviewed by a county board in that specific case. We're past that. Special magistrate made his initial ruling. They didn't like it. They have a right to have that opinion. But the next step, it goes to trial. What that sentence means in layman's terms is, you're not going to take the case mid-trial. That doesn't make any sense, to take something that's already moving forward with the special magistrate and then suddenly bring it to you, when there's nothing in the documents on that agenda that really give you any idea what's going on in this case. The other problem is the Santa Rosa County Land Development Code. That's the provision that Mr. Andrews said applies today. And I understand why he's making that argument, because if you read the provision that Mr. Mead cited applies, it references the County Board of Adjustment. Doesn't really apply. I mean, in all honor, in all candor, this provision, if you could clean that up, it'd probably make it a little clearer. But Mr. Andrews' point is, this provision doesn't exactly apply. Problem is, the one that Mr. Andrews cited doesn't specifically apply either, because it deals with the appeals from that chapter of the Land Development Code. Well, some of the other issues that are referenced on that notice of appeal reference the Florida Building Code. It's not completely clear either, but it does say if there is an error in any requirement, decision, or determination. Well, we haven't gotten to the point where there's been a determination on that. That happens when the special magistrate makes his decision on it. So if you want to go the path of the most efficient, the most likely to protect the citizens of the county by making sure we don't jeopardize what the flood insurance program has done, the community rating this county has that affects all the flood insurance premium, this case needs to go back to the special magistrate. And then it may come back to you. In all candor, I think it probably will come to you at some point, but it'll at least come to you with a record. Otherwise, we're going to start hearing testimony, and my guess is your eyes are going to start glassing over because you're not even going to have a full perspective of what the issues are. And I'm not sure you're going to get clarification depending on what witnesses are here. It didn't even sound like Mr. Meade was aware this was going to be an evidentiary hearing. But if you take it in front of the special magistrate, I guarantee you everyone's going to get that due process. They may not like the outcome, but they're going to have the ability to figure out what witnesses they want, what exhibits they want to put before the court. And then at that point, the determination is going to be made with a clear record. That's where it needs to go. Because right now, if you go either route, if you go the route that Mr. Meade proposes, watch out. Because you're making a seriously dangerous decision that could affect the flood insurance program. Because if FEMA or the State Floodplain Administrator looks at it and says Santa Rosa County isn't enforcing their code, you're jeopardizing the flood insurance program. If you go the direction of what Mr. Andrews is arguing, what's almost certainly going to happen is they're going to file a writ of certiorari, whether or not due process was met in this appeal. And then at that point, when all that gets cleared up, are we going to resolve the issue? No. All we're going to have figured out is what are the technical requirements that apply, only to then go back to the very beginning with the special magistrate. My clients have lived on their property for 20 years. And I'll tell you right now, the last two or 3 years, they have been sleepless, worrying about the next hurricane that may come in. And in all fairness, perhaps the same stress is on the Vorshakens, wanting closure in this matter, because they don't know when it's going to end either. It needs to go back to the place where evidence can be considered, the way that it gets handled in every other matter, and that's with the special magistrate. So I think you've got a decision to make right now on which path you go, because you're either going to have to go the route of starting to hear evidence, at which point is Mr. Meade going to bring in evidence? Are we going to bring in evidence? Exactly how's that going to work? Because you're going to have to start making evidence code determinations. What gets in, what doesn't get in. And unless you're familiar with those code provisions like the special magistrate, you're going to have a problem. And we're going to be here all evening, and at the end of it, I don't think we're going to be at any clearer point than where we are right now. If you have questions on that point, I encourage you to ask them now. I'll be happy to field them. I think Mr. Meade can make whatever arguments he wants, but you really need to get an answer on what the ultimate end goal is on this.
Mr. Hoffman, are you saying that the issue is not ripe, or what basis for demanding it back to the special magistrate are you using?
That's exactly what I'm saying. It's not ripe. The special magistrate made a ruling on a motion to dismiss, which just means the case moves forward. You go to a trial. That trial has not occurred. The case management order was entered, scheduling it for a trial, laying out all the parameters how it was going to work. Very efficiently, I might add, too, given the fact it took 2 years to get to the point where we had a notice of violation filed. So at this point, let that process play out. We're not talking about sending something down to the nowhere land where it doesn't come back out for another year or two. That thing's going to move forward quickly. Our hope is that before the end of summer, before the next hurricane season comes, we'll have a resolution. And at that point, if either party doesn't get a favorable ruling, they can come back to you. But you'll actually have some information on it to have some idea of what the issues are to be considered.
Mr. Andrews, could you address that particular request there and the legal issue there?
I don't think that the board is precluded from making a determination that you're not going to make a determination, I guess. I mean, that's what he's saying, is that you're going to say that this, I mean, the appeal denial settles the issue as far as I'm concerned. If the board doesn't feel that they're ready to make that determination, we certainly can direct it back to the special magistrate. I mean, the provision is that if there's that they'll postpone it, and the order postponed it until there was a determination by this board. If the determination is that you want to remand it to the special magistrate, I don't see that you're precluded from doing that.
Mr. Hoffman, answer a question for me. You tell me the special magistrate's made a determination, but then I also hear the special magistrate is not finished with it. Clear me up there, help me.
I've referenced a motion to dismiss at the beginning. I'm going to try to eliminate the legal jargon and explain what that means. When a case gets initially filed, lawyers will often file pleadings to try to get the thing done at the very beginning, cut a case off before it gets started. Sometimes you'll see Jack McCoy do that on Law and Order, where they try to go in there and cut something off at the very beginning when a party's making a defense. At the very beginning, that was filed. And the judge said, you know what, I'm going to hear the evidence in this case. And that's when he issued the case management order. So as far as any party being...
I'm sorry. Mr. Hoffman is representing interveners. If there's going to be, if you're going to take issues with regard to the procedural posture in the case, my clients are the parties. And I think we should be discussing that with this county attorney, not with the interveners, whose only position here is to be able to speak to the issues, not to try to push the questions one way or the other.
Well, then you answer the question for me.
Certainly, I'd be happy to.
Let me hear from him, Mr. Hoffman, since he made that interjection. The question was, how do I determine as a board member when I'm hearing the special magistrate has made a ruling, and then I hear the special magistrate is not finished with it? What's the difference?
The motion to dismiss was framed on the basis that we could not identify the technical standard. As Mr. Andrews identified to you, the code provision we're appealing under, the lack of that technical standard, if we do not appeal before he goes to hearing on the main issues, we would waive that. In other words, the fact of there being no technical standard we can identify and to be able to prosecute our defense of the violation would mean we give up that issue if we didn't bring it to the board at this time. And so I disagree respectfully with Mr. Andrews and Mr. Hoffman's contention that you just send it back to the special magistrate because it's not right. Well, if you will point to an authoritative provision that is the technical standard to be applied in this hearing, it goes back to the special magistrate under that standard, and it's that standard we are lacking and that we are here to get.
Mr. Chairman. Wouldn't the special magistrate, if he couldn't understand the technical aspect, come back to us and ask us for that clarification?
The code does not provide for that.
Well, wouldn't the special magistrate tell us that?
The code does not provide for that. That's all I can tell you.
Answer Michael, if we went back to the special magistrate and said, this is it, he would come to us and go, I don't quite understand your code, can you explain it? Wouldn't he?
He could ask for clarification, or the parties could ask for clarification based upon his preliminary interpretation of whatever that is.
Right.
But the fact of the matter is, if we don't make this appeal now and get a technical standard, one, we have no basis to go forward for due process purposes. We don't know what we're supposed to prove.
Well, but I still contend that the special magistrate would want that clarification from us. I mean, he wouldn't take it without...
That's why he postponed things, so that we could get that determination, because...
Well, now, see, that's new, because I heard he just dismissed your motion to dismiss, not a motion because he doesn't have technical information, Roy. I'm going to ask my attorney.
What the special magistrate did was, when this appeal was filed, was postponed the hearing, stayed the case essentially until the board made this determination. The determination that was set by the administrative appeal, which I don't think is, as framed by Mr. Mead, some technical standard that has to be expressed by this board. It's whether or not the applicant has presented sufficient evidence to demonstrate that fill will cause no harmful diversion of floodwaters or wave runoff and wave deflection that would increase damage to adjacent buildings and structures, that insufficient evidence has been provided to demonstrate the retaining wall will cause no harmful diversion or floodwaters or wave runoff and wave deflection that would increase damage to adjacent buildings and structures, or that excessive filling of property and construction of retaining wall will likely alter natural functions, resulting in a damaging increase in erosion, habitat destruction, or adverse impacts on the water quality treatment function of the floodplain. I disagree completely with Mr. Mead that we have to have some standard of wave analysis. We have expert testimony, more than sufficient expert testimony for the board to make a determination as to whether or not those standards have been met. And that's what the floodplain administrator relied on in making her determination. Her determination comes to this board, by the way, with a presumption of correctness. So I don't see any reason we can't go forward and determine whether the notice of violation is substantiated, essentially.
And if I may, our question is, what's sufficient? We don't know. We can't find a rule. We can't find a standard in the practice of the building official. We've looked. We've presented it to you in the appeal, so you can look at it for yourselves. We see that the practice of what was actually submitted and approved, both in the permit and the revision, has been approved in other settings. So if we were to rely upon that, that certainly gives us grounds that that must be sufficient because permits have issued on that. And so that's the question, what is sufficient? That's the heart and soul of the issue that the hearing is to decide, and we don't know. And how can we go prove
The
the sufficiency?
determination of the building official is what comes to this board to make a determination whether that's substantiated.
On what
And-
standard? What is sufficient?
We don't, the determination of the building
I
official.
apologize. But one point to answer the commissioner's question.
The determination is whether or not to sustain the decision of the building official or not. That's what's before the board tonight. Not to set forth some type of wave analysis standard, but whether or not you're going to support the determination of the building official that these violations exist.
May I?
That was just to clarify. Our role is not to set forth the standards, as Mr. Hoffman indicated some concern with. We're not adopting standards. We're recognizing that our building officials' determination was based upon competent substantial evidence.
That's correct.
May I, Mr. Chair? That's fine.
The one point, your question, Commissioner, about how it would be handled by the special magistrate, if there's a problem with the technical application of the code provisions, you'd question the business of, Mr. Royals at trial. There'd be testimony there. The special magistrate will weigh the evidence and make a decision. If there was ambiguity in his mind, he could make a ruling and state forth in the order, this is what I think, but this is where the confusion lies in the code. And then at that point, it comes before you, if it went up on appeal at that point, and you know exactly what the issue is. So that's well within the special magistrate's ability. So I think I'm in agreement with what Mr. Lyncher just said. If you make the determination that we're going to allow the building officials to move forward with the violation, it goes back to the special magistrate to make the ruling.
I must respectfully disagree with Mr. Andrews because the question of you supporting the decision of the building official is the ultimate question at the end of this process. Secondly, with respect to Mr. Hoffman, I would much prefer that we have an appeal on a full record. That is an ordinary course. The problem is your code says we waive this question of what is sufficient. In order to make that standard, we have to go prove in this hearing if we don't raise it before the hearing and bring it to this body for appeal. And if we go back, what are we supposed to apply? That's our question. And I'm here telling you, we haven't found it. The county hasn't said it here tonight. Mr. Hoffman hasn't identified what standard is sufficient. I'm not asking you to invent one. I'm saying somebody needs to point to what standard makes that measure of sufficiency that will be quantitatively adequate in the language of the violation for us to meet. And if we can't, that's a due process violation, and nobody wants to have to deal with the consequences of that, for heaven's sakes. So that's my appeal, is either agree that we haven't found that standard and therefore this violation can't proceed to hearing because we don't have a law to apply on that standard, or if you do what Mr. Andrews suggests, I don't know where that ends up because I don't know how I'm going to try a case. I don't know what I'm supposed to prove.
Any discussion from board members? All right, this time I don't need to hear from Rhonda. I think she does a good job. We see her in action every day. Unless other board members feel like they need to hear from Rhonda. Right now, Roy, tell me what the ramifications are to the board if we uphold the opinion of our staff and Ms. Rolls.
Well, if we're not going to take, We have Ms. Royals here, and we also have Mr. Brett Webb, who is a wave analysis and who set forth his opinion as an expert as to the standards that we will be dealing with. I think it would probably be helpful to put in the record both of those at this point.
I would object simply because we haven't been provided with any notice of Mr., what was his name? I didn't catch it. Mr. Webb's opinion, that we...
You've got copies of Mr. Webb's opinions.
Well, that's nice. That's the first time hearing that that's going to be the substance of what he's going to be testifying here tonight so that I can meet that with appropriate cross-examination, and that's simply not appropriate. I was not told, one, it would be an evidentiary hearing. Two, I wasn't told what I should be prepared for to respond to that evidentiary hearing with any contending evidence, like, for instance, if I was going to have a competing expert, because this is an appeal. And I agree, the substance of these questions has got to be addressed in an eventual hearing, but what that hearing can't address is what is the standard to be applied, and we don't have one.
Roy, what's the quickest way to get this back to a special magistrate? Support Rhonda's opinion?
Well, supporting Rhonda's opinion is what the board should do.
All right. Mr. Rolls, if you guys will sit down, I'm going to hear. Mr. Rolls, if you'll come up and describe to this board what your course of action was, please.
Yes, sir. Rhonda Royal, Santa Rosa County Building Official. If you can bear with me, I would like to read over what I prepared. I should only take about 10 minutes. I know there's been a lot of information, but I think it's important that the board understand where we started and why we're here tonight.
Okay. You have the floor.
Thank you. As Mr. Mead, Mr. Hoffman stated, we're here tonight to, they're appealing, or Mr. Mead's clients are appealing my decision to revoke their building permit. We issued a permit for development of a seawall at 4901 Soundside Drive. It was issued to Mr. and Mrs. Borozinskins. The subject permit was revoked for the following violations of the Land Development Code and Florida Building Code. Section 10.09.12 of the Land Development Code places limitations on fill, and fill should be designed to be stable under conditions of flooding, including rapid rise and rapid drawdown of floodwaters, prolonged inundation, and protection against flood-related erosion and scour. Additionally, in Section 10.0915, that places limits on the alteration of natural floodplains. Furthermore, in the Land Development Code, Section 10.1307, other developments such as a seawall, retaining wall, and fill in coastal high hazard areas requires an engineer analysis. The wave analysis must demonstrate no harmful diversion of floodwaters or wave runup and wave reflection that would increase damage to adjacent buildings and structures. Additionally, in Section 10.1308 in the Land Development Code places limits to non-structural fill in a coastal high hazard area. The Borozinskins property is in a what we call a V zone. It's subjected to wave action. In those zones, only minor grading and placement of minor quantities of non-structural fill are allowed around buildings for landscaping and for drainage purposes. And then fill with finished slopes greater than 1 unit vertical to 5 units horizontal shall be permitted only if another wave analysis is prepared by a qualified registered design professional. Additionally, the Florida Building Code references ASCE standards, which is a standard that mirrors the language that we have in our Land Development Code. Because up until probably, I believe it was in the might have been the 2007 code, local jurisdictions regulated floodplain development. The Florida Building Commission acted upon adding floodplain regulation to the Florida Building Code because there were jurisdictions in the state of Florida that did not participate in the National Flood Insurance Program. And then the building code also addresses erosion control structures and that they shall be designed and constructed as not to focus on or increase flood forces or erosion impacts on the foundation of any structure. As a participating jurisdiction in the National Flood Insurance Program, Santa Rosa County is required to adopt and enforce floodplain regulation that is compliant with federal regulation. In addition, as I stated, the Florida Building Code also establishes floodplain development regulation. The provisions of Santa Rosa County's floodplain management and the requirements in the Florida Building Code applies to all development that is wholly within or partially within any flood hazard area, including but not limited to this installation of steel walls, retaining walls, and placement of fill. The intent of the regulation is to establish minimum requirements to safeguard the public health, safety, and general welfare, and to also minimize public and private losses due to flooding through the regulation of flood development in flood hazard areas. Additionally, the floodplain regulation is intended to be administered and enforced in conjunction with the Florida Building Code. It identifies the building official as a floodplain manager who may delegate performance of certain duties to other employees, such as we do here in our county. Now, I'm acting as building official, but also as the floodplain administrator of Article 10 of Santa Rosa County Land Development Code. But the day-to-day operations are, we designate our floodplain manager to perform and participate in our local mitigation committee meetings and so forth. The interpretation and application of the local floodplain regulation shall be considered as minimum requirements, liberally construed in favor of the governing body, and deemed neither to limit nor repeal any other powers granted under state statutes. Additionally, the building official is authorized to enforce the provisions of the Florida Building Code and shall be the authority to render interpretations of the Florida Building Code. Pursuant to Land Development Code Section 10.0307, the building official is authorized to suspend or revoke a floodplain development permit approval if it was issued in error on the basis of incorrect, inaccurate, or incomplete information or in violation of the floodplain regulation. The same authority is granted to the building official in Ordinance 2006-37, but extends to any violation of any ordinance or regulation or any violation of the provisions of the Florida Building Code. Ordinance 2006-37 is our administrative code of the Florida Building Code. Santa Rosa County adopted and replaced Chapter 1 of the Florida Building Code in our ordinance. Just to give you some quick background, the seawall in question, the permit was issued on May 10th, 2017 for the construction of the seawall. And as we've stated, as a condition of that permit approval, the applicant had to submit a wave analysis. The property owners submitted a wave analysis that was prepared by ECM Engineering, which was certified by John Elamod, professional engineer. It was our belief that the analysis, and I believe you have a copy of that in tab 4 of your backup, provided adequate data in order to approve the floodplain development for issuance of a building permit. He gave conditions in that wave analysis and provided a statement of no adverse impact to adjacent structures or buildings. As Mr. Mead had, I believe it was Mr. Mead stated that the permit was subsequently modified from a seawall at mean high tide line or high water line to a retaining wall later on. After field development began on the property, we received a complaint of red clay being placed on the property. Our Code Compliance Division investigated the complaint and discovered there was in fact a red clay violation. A notice of violation was issued to the property owner, and they voluntarily brought the site into compliance. After receiving additional complaints about fill on the property, our code compliance supervisor issued a courtesy letter over our concerns that there was an area that was built up quite high. It was along the east property line. Now, I've referred to this area as the pad area because it was significant and it was near the east property line. We received written and verbal communication from the Vorzinskins stating that they intended to use the fill to backfill the retaining wall. Then on October 10th, 2017, I still had concerns about the fill because we were continuing to get complaints with several of the neighbors in that area. So I contacted the engineer of the wave analysis, with, again, John Elamod, to discuss the height of the proposed wall and his, how he arrived at his analysis. His comment to me at that time, he said that if the wall was built according to his report, the wall would provide the necessary protection to their property, meaning the Voronezhins' property, while not causing any damage or adverse impact to adjacent properties and structure. This was also discussed with, I contacted the engineer of record who had developed the detail of the wall. So you had John Elamod, who performed the wave analysis, and then a gentleman by the name of Dean Spencer, who's also a professional engineer out of Pensacola, that designed the actual detail. It was then after, I guess it was the following month, still having the concerns about the dirt, I sent an email to Mrs. Voronezhin expressing my concerns about the fill activity and outlined the regulation that places limitations of fill in coastal high hazard areas. In that email, I requested that they provide additional wave analysis on the fill that had been placed on the property. Over the next several months, the lot continued to be monitored to ensure no additional fill was being brought in. However, on February 26 of 2018, I was forwarded an email that showed pictures of additional fill being placed on the property. We had not received any wave analysis regarding the fill, so I immediately requested a cease and desist order. One was issued that day. Then, a few days later, it was actually on March 2nd, 2018, the code compliance supervisor and myself spoke with State Floodplain Manager Office regarding the development of the property. They reached out to me, and we had a conference call with several people, including a representative from Region 4 in Atlanta. They too had concerns since a recent scheduled community visit raised questions about the amount of fill. We discussed the substantial filling of the lot and the potential floodplain and building code violations. We agreed that that additional data was needed from the engineer of record. The state floodplain manager actually raised a lot of questions about lacking certain data, and we discussed that he talked to me about calculations, and I told him that even if we had someone submit calculations, we didn't have an engineer on staff that could verify the calculations. So we ended up agreeing that we would send a letter out to the property owner asking for more data. We amended, that day we amended our cease and desist order to cease all development, not just filling of the property. And then I followed up with a letter, once I received a written letter from Mr. Martin that they needed to contact their engineer of record to provide additional data to substantiate his conclusion of no adverse impact on the wall and fill. Attempts by Mr. and Mrs. Voronezhin to obtain additional engineering data from Mr. Elamod became problematic since they expressed to me that Mr. Elamod was not returning their calls. After several weeks passed, I still had not received the data that I requested. I personally contacted Mr. Elamod myself over the concerns that we were having, and he again asserted that he had been taking all conditions into account, and based on his analysis, he utilized FEMA technical bulletin for, I believe it was 593 is what he quoted, for 100-year base flood, and used the wave wash hazards theories outlined in FEMA's coastal engineering. It was at this point I asked him if he had seen my letter, the letter that I had sent to the Voronezhins, as well as a copy of the letter from the state floodplain manager. He advised me he had not. So I emailed him a copy. He called me back within a few minutes and stated that his wave analysis was no longer valid since the wall had been modified from a seawall to retaining wall. He followed up with an email dated May 29th, which states, Rhonda, due to the construction deviations of the retaining wall, the original concept, upland relocation, wall height, added fill, etc., a new wave analysis should be required take into account all existing conditions of the retaining wall site, topography, stormwater management, runoff flow, added fill, et cetera, to address all concerns associated with this project. Now, I'll say this, that during my conversation with Mr. Elamad, I specifically talked to him about had he had his boots on the ground at this site when before issuing his waive analysis. He told me he had not. I asked him what did he use to determine, what did he use in determining his wave analysis, and he said that he had used GIS imagery, LiDAR, and then, of course, the FEMA bulletins that I mentioned before. Since Mr. Elamad had nullified his wave analysis, I notified Mr. and Mrs. Vorzinskin of that, and I believe, if I'm not mistaken, Mrs. Vorzinskin had attempted to get with Mr. Elamad to get additional data to us, but that was not successful, so she contacted me that they decided that they would hire a new engineer because it was taking so long. That's where their second wave analysis comes in. This one was issued by, and I think I get the names transposed back, but Cummings-Cedarburg report, and I believe that's part of your documentation as well. They did submit a report by Cummings-Cedarburg. The report is based on using existing profiles utilizing the Coastal Hazard Analysis Modeling Program, also referred as CHAMPS. It had a lot of data in it, but I wasn't familiar with it. I did do a review on the FEMA Hazard tutorial. I read through that. But one thing that did stick out in that report, it says in section 2.1, it states the CHAMPS program was used to determine wave heights, wave crests, elevations, flood zone designations, and location of zone boundaries along a given transect. After reviewing the report, I had concerns that the report seemed to lack computations on wave run-up, wave deflection, and only seemed to calculate wave heights with a wall and without a wall. Therefore, I contacted Steve Martin, the state floodplain manager, for guidance. It was a few days later that Mr. Martin reviewed the Cummings-Cedarburg report. He then sent me an email, and in that email, I'll just paraphrase, the study does not quantify the dynamic effects of wave actions imposed on the obstructing wall and fill. Furthermore, he stated, quote, the amount of fill placed on the property far exceeds any reasonable interpretation of minimum fill for landscaping purposes, which is the basic standard of the National Flood Insurance Program and local ordinances. Based on that and discussion with Mr. Martin, initially he was going to have his engineering staff do a courtesy review of the Cummings-Cedarburg report, but I felt it best that I seek an independent coastal engineer to review that report. So with approval, I retained Mr. William Miller with Taylor Engineering, and based on his review of the report, he concluded that the Cummings-Cedarburg wave analysis did not adequately demonstrate no adverse effect on adjacent buildings and properties. Therefore, based on the John Elamad wave analysis being rescinded by Mr. Elamad, the second report had been reviewed by the state floodplain manager as well as an independent coastal engineer. The decision was made by myself to that revocation of the permit was in order due to violations of our land development code and Florida building code.
And just, Ms. Royals, that review provided by Mr. Miller is in the package provided to the
Yes, sir, I'm sorry. Tab 8.
Okay.
I'm sorry, that would be tab 8.
Tab 9, I think. Actually.
Oh, I'm sorry. Yes, you're right. I got out of order. Yeah, and Steve Martin's email to me is actually in tab 8. And then Taylor, Mr. Miller's report or review is tab 9. So I issued on September 27th, I issued the notice to Mr. and Mrs. Vorazinski that stating that the wave analysis that Cummings Cedarburg submitted did not provide adequate data. Now, I did review Dr. Brett Webb's report on the Cummings Cedarburg. And if I may, I'd like to just quote something that.
Chairman, just for the record, I object to any reference to Mr. Webb's report. It was procured by an adverse party who was not properly involved in this proceeding, and as a matter of due process, I don't think it's appropriate for Ms. Royals to introduce evidence of a third-party opinion hired by a private party who's adverse to my client.
Noted.
Okay. So should I go ahead and read it? Okay. That Dr. Webb was hired by Mr. Fairbanks, an adjacent property owner, to review the Cummings Cedarburg wave analysis. Based on Dr. Webb's review, he concludes that the analysis and statements provided in that report does not support their conclusion. I just wanted to mention that. Therefore, as I stated before, there's several violations of the Land Development Code, the Florida Building Code, violation of the section 10.0912. The subject property has been filled with no evidence to support that it is of minor quantities for landscaping and for drainage purposes, nor that the volume distribution of floodwaters or wave run-up will cause no harmful diversion of floodwater, wave run-up, and wave deflection that would increase damage to adjacent property. Violations against 1009.15. Subject property has been substantially filled that will likely alter natural functions, resulting a damaging increase, erosion, habitat destruction, or adverse impacts on water quality treatment functions of the floodplain. Section 10.13.07, insufficient evidence has been provided to demonstrate the retaining wall will cause no harmful diversion of floodwaters or wave run-up and wave deflection that would increase damage to adjacent buildings and structures. Section 1013.08, insufficient evidence, again, has not been provided to demonstrate the fill will not cause adverse effects on neighboring properties. And then, of course, ASCE 24, Section 4.5.04, fill has been placed on the property with no evidence to demonstrate that it is of minor qualities for landscaping and for drainage purposes, nor that the volume and distribution will cause no harmful diversion of floodwater, wave run-up, and wave deflection that would increase damage to adjacent property. And I believe the last section is ASCE 24, Section 4.7, there's no evidence to demonstrate that the retaining wall will cause no harmful diversion of floodwater or wave run-up and wave deflection that would increase damage to adjacent properties and structures. Therefore, I submit today the development located at 4901 Soundside Drive is in violation of the aforementioned floodplain development provisions of our Land Development Code and the Florida Building Code, and therefore recommend that the board deny Mr. and Mrs. Vorazinski's appeal request. In closing, I know you've already, one of the attorneys had already mentioned this. It's important for me to say this, that as a participating community, Santa Rosa County participates in the National Flood Insurance and the Community Rating System. We are required to enforce the provisions of their code. We have to adopt floodplain regulation that is consistent and meets the federal government's requirements to be a participant. These are voluntary programs, and Santa Rosa County has been in the National Flood Insurance Program, I believe, since 1976. We've been a participant in the Community Rating System probably since the mid-90s, if not later. And in failure to enforce the provisions of our ordinance can jeopardize a community's continued participation in these two programs, resulting in loss of flood insurance, federal aid, flood insurance premium, and flood insurance premium discounts. Does the board have any questions?
Rhonda, thank you very much. That clarified quite a bit for me. I think you did an outstanding
Thank
job
you.
in your performance of your duties.
Chairman, I have a couple of questions for Ms. Wells, if I may.
John, just stand up here.
That's fine.
So,
May I proceed?
go ahead.
Thank you. Ms. Royals, and then very brief, I have about half dozen. You articulated what the gentleman at the Division of Emergency Management described as things that he felt needed to be shown in the Cummins-Cedarburg report, and you articulated those to the panel. And I'm sorry, can we please have her sworn for my questions? Because I would like this to be evidentiary, since we're supposedly going to be evidentiary here today. Thank you. Do you understand the question that I just asked?
No, ask again.
I certainly will. You articulated his statements with regard to what he felt needed to be supplied in the Cummins-Cedarburg report and he felt was not supplied in the Cummins-Cedarburg report. Did that articulation of those issues establish in your mind the standard that had to be met for the wave analysis for the permits in question?
No.
Okay. Then what relevance did it have?
He addressed the LMOD as lacking certain technical data, such as swell heights, and right off the top of my head, I can't remember all of it. The Cummins-Cedarburg report, his discussion with that was that it was, in his opinion, and his staff's opinion, that that program is utilized for determining, it's utilized for mapping of flood zoning and determining flood depths, so that it was not a program that would be utilized for analyzing wave run-up and wave deflection.
And did he identify what the appropriate standard was for a satisfactory report that would meet the standards of the provisions in question?
No.
And can you articulate to the board here tonight, what is that standard?
To my knowledge, there is no minimum standard that I'm aware of.
Thank you. And lastly, with regard to the question of you identified to the board that you had a cease and desist on the fill questions because you were still addressing those issues, and then subsequently you had communications with the Division of Emergency Management and then had the entire development stopped because of those questions. Is that a fair characterization of your testimony?
Yes, sir.
And in regards to that chronology, there had not been a final inspection or representation by my client that all of the fill and grading activity had been completed at that point, had there?
No, not that I'm aware of.
So the state of the fill as it stood at the cease and desist may or may not have been what was the final fill situation intended to be compliant with the permit. You don't know whether it was or wasn't, do you?
I authorized the cease and desist based on the amount of fill. In my
To be
opinion.
clear, I'm not questioning the cease and
Yeah.
desist. I'm simply saying that there was no representation by my client that the condition of the fill at the site on the date of the cease and desist was somehow supposed to comply with the permit rather than being temporary in terms of moving things around to get to final grade.
And I guess I'm not understanding your question, because the.
I'll clarify.
Okay.
Was there any representation by my client that the status of the fill at the site was the final grade intended for the permit?
No.
Okay. That's all my questions. Thank you.
Thank you. Rhonda, again, thank you for, bringing us up to speed on that. Unless the board's got any other questions.
Excuse me. Mr. Webb is here. He's got some documents that are in the file. I'd like to have him briefly summarize those.
All right, Mr. Webb.
If you would come up.
For the record, I renew my objection.
Noted.
I expect.
Thank you.
My name's Dr. Brett Webb. I'm a professional engineer registered in the states of Alabama and Florida. I'm the Vice President and Senior Coastal Engineer at South Coast Engineers, located in Fairhope, Alabama.
May I ask if you want to speak to be sworn?
Yes.
I do.
Dr. Webb, did you prepare a coastal engineering analysis for the Fairbanks, I think it was, that's dated June 18, 2018?
Yes, sir, I did.
Okay. And a copy of that, for the record, is in your package, Commissioners, at tab 5. That's a 28-page document, so I don't want you to read it all to the commission, but would you briefly at least summarize the conclusions that you reached and what the basis was for those conclusions?
Yes, sir, I will. I use two methods to determine, or basically to assess, whether the wall, as it had existed at the time of my site visit last summer and in summer 2018, would potentially cause a diversion of waves or flow onto the Fairbanks' property during a base flood event, which is essentially a large hurricane. And both of those methods, and in the report they're labeled as the simplified method and the more detailed method, both agreed with one another that regardless of methodology applied, and both methods are in keeping with standards outlined in the Coastal Engineering Manual and the Practice of Coastal Engineering, that the presence of the wall as it existed at the time of my site visit would cause a deflection and a reflection of waves onto the Fairbanks' property that could potentially cause increases at his structure location, up to a factor of 2 times larger than without the wall. There would also be a diversion of floodwaters that would exist until the floodwaters reached and exceeded the elevation of the retaining wall, which is at about an elevation of plus 6 feet. And the flood hazard elevation there is at about plus 10 or plus 11 feet, depending on where you're standing on the property. So almost half of the potential flood elevation being obstructed by the presence of the wall. And so both of these things would actually cause waves and flow to be diverted to the Fairbanks property, in contrast to the wall not being there. There would also be localized erosion along the wall on the Fairbanks property as a result of that. And more clearly, the fact was that if you look through floodplain ordinance and regulations, the placement of non-structural fill of a reasonable amount in a special flood hazard area is allowable. And so the question is, what is reasonable? And some municipalities have outlined, and some provisions outline what is reasonable. And it's certainly not building a retaining wall up to an elevation of plus 6 feet. And so these reasons basically are some of the evidence that goes into the analysis to show that the presence of the wall would have an adverse impact on the Fairbanks' property.
Okay.
All right, and what you're describing, is that commonly referred to as scouring, the damage done from the water being opposed from a wall or retaining wall, any type
Yeah,
of,
the more general name is erosion, but it is scour. So when you have flow or waves interacting with the structure, we refer to that as scour.
And would it be a reasonable statement for, just terminology or bringing it down to a level, you're educated in that. We got gentlemen here that are educated in the laws of our land, that basically the way I look at it, anything sticking out in the water that far, when it gets hit by a wave, if it's solid, it's going to deflect, it's going to cause more damage on either side. Would that be a fair statement to make or to consider?
It is, but again, a lot of these determinations are somewhat site-specific and also structure-specific. Here at this site, the location of the wall on the upland and the elevation of the wall adjacent to the Fairbanks' property presents some additional problems that we typically don't see in traditional or standard shoreline stabilization projects where somebody's just installing a seawall that runs along the water side of their property. These walls typically do not return at significant elevation along the property boundaries. And it's really these return walls that pose the largest potential impact for adjacent properties, because the existence of those walls above normal grade elevation basically creates an opportunity for waves to reflect off those walls and flood flow to be diverted around those walls. And so it's a non-standard way of stabilizing shoreline, and that's because it's not shoreline stabilization as it exists right now because it's above the high tide line. It's basically there as a retaining structure for fill placed on site.
Okay. Any questions by fellow commissioners? Mr. Andrews?
One other thing, you also performed a review of the Cummins-Cedarburg analysis, is that
Yes, I did.
correct? And that review was performed on September 2nd, 2018?
Yes.
And for the record, that's in your package at tab 7. Did you find that the Cummins-Cedarburg report was substantiated quantitatively or otherwise?
No, there's no way that the tool that they applied could ever address the question. The tool as it exists, like Ms. Royal stated, this is a tool that is commonly applied in flood hazard mapping. But it's limited in terms of what it can be used for outside of that. And this is a case where it's the wrong tool to use for the job. The reason being that the way that the model is applied, it will give you information only about what's happening on the Vorshakens property. It won't tell you anything about deflection of flow. It doesn't even talk about flow. It really only handles wave properties. But it can't tell you what's going to happen to waves off of their property because they didn't do any analysis to demonstrate that. And the model's really not capable of doing it in that way. The model's also not capable of addressing some of the other processes which are mentioned specifically in the floodplain regulations, which relate to not only diversion of floodwaters, but wave run-up or ramping on the wall itself. So there's just a limitation of what that tool can do, and it was just an inappropriate application for the tool.
Well, would the submission of that report be sufficient to evidence to support that fill placed on the property is of minor quantities for landscaping and drainage purposes, and that the volume distribution will cause no harmful diversion of floodwaters or wave run-up or wave deflection that would increase damage to adjacent buildings and structures?
Are you referring to the Cummins and Cedarburg report?
That's correct.
There's no way that their report can speak to that.
Okay. Would that report provide evidence that the retaining wall will cause no harmful diversion of floodwaters or wave run-up and wave deflection that would increase damage to adjacent buildings and structures?
No.
Would it provide evidence that the fill will cause no harmful diversion of floodwaters or wave run-up or wave deflection that would increase damage to adjacent buildings and structures?
No.
Okay, that's all I have of this witness.
One last question. There's been several comments about there's no standard. I find it hard to understand that there's no standard in a science that we rely so much on. Can you help me understand that a little better?
We do not have, for the types of engineering analysis that's being requested in these types of permit applications, there are recommendations in their guidance, but there is truly no professional standard that is outlined that one shall follow every time. We do have documents that serve us in our capacity as coastal engineers, and the primary document that we rely upon is the Coastal Engineering Manual. And that was published by U.S. Army Corps of Engineers. It was originally dated 2002. The previous edition that we typically used and referred to, somewhat inappropriately as the Bible of coastal engineering, was the Shore Protection Manual. These are the tools that we have in our profession to perform analyses that speak to the requirements of an engineering analysis of waves at the property that's being requested in these types of situations. And so we apply our technology and the fundamental understanding of our theories that we have in those cases as they're outlined in these documents, and that's what was done in this case.
So perhaps standard is a bad terminology because it certainly sounds like there's nomenclature, analyses, other proof, past history, if nothing else, that professionals like yourself make fairly positive determinations on?
I think the issue at hand is somebody being able to understand when, there are really two issues. One is a lack of evidence. Mr. Mead said earlier that, an expert should be able to offer their opinion. And the practice of engineering, in my opinion, since I'm offering it, is based on evidence and supporting information. And when you don't provide that supporting information, you really then are putting 100% of your faith and your ability to make a determination based on somebody's opinion that lacks any supporting information whatsoever. So number one, that's a concern. The second concern here is that when a qualified coastal engineer actually performs an analysis that speaks to the issues but applies an inappropriate tool. Now, that's not to say that tool is not part of the practice of coastal engineering. It is, but it's just applied in a different situation. So what this really boils down to is applying the appropriate standards and appropriate technology for answering the question at hand, and whether those tools can actually answer the questions. And in my opinion, as I wrote in my review of the Cummins and Cedarburg report, that model or that tool is just incapable of doing that.
Okay, and all the methods you use for your process are the same as the Army Corps of Engineers would use. In fact, they developed these.
The simplified methods are all outlined in the Coastal Engineering Manual. And then the more detailed method, which is a numerical wave model, is a numerical wave model that the Corps of Engineers routinely applies in many of their projects. But again, it's a tool, but it's a more appropriate tool for the issue at hand.
Okay, thank you. Anybody else? All right, thank you very much. Appreciate it.
You're welcome.
Mr. Chairman, may I close? Because I think we've heard everything we need to hear subsequently. And I just have a couple of points with regard to what these two folks have said that I think will elaborate the key point we're here.
All right, what do you need, 5 minutes?
Nothing, not even that much.
Okay, thank you.
Ms. Royal said there is no minimum standard. That was her testimony. I didn't invite her to testify, Mr. Andrews did, but that's what she said. He said there's no standard. He said there's lots of methods, there's lots of things that can be done, lots of things that can be applied, some may be right, some may be appropriate, some may be not. But when we are holding somebody's property rights hostage in law, we need to have something that they can understand and know that they are bound by. That's the legal standard. And simply saying that it's not quantitatively adequate is not a standard unless you've given a measure by which that standard can be met that is intelligible to someone. Ms. Royals is a capable professional person. I don't doubt that. And she tries to do her job well. She can't write the code. She can issue interpretations. She didn't do that before this issue. With respect to her dealing with the Cummins Cedarburg report, she identified deficiencies, but she didn't then say, these are deficient. Here's what I need to see. And then offer my clients the opportunity to provide those things before they were set into a revocation of a permit that they had spent $97,000 plus on, and a violation proceeding if she can articulate a standard that will satisfy her discretion based upon all of these things and allows my client the opportunity to provide it, there's no reason for us to be here. Because it can be done if we can have someone articulate a standard. I'm happy for her to do that. If that's a reasonable exercise of her discretion, I'm happy to derive that from her past history, but we can't, as I've shown you in the materials that we have. Or I'm happy that she issued interpretive rulings saying this from now on shall be what you do. But what we have done to this point is in place, and it cost a heck of a lot of money, totally in reliance upon what the county told us. And they had no reason to guess otherwise, because there's nothing written down that you can look at. So I would simply ask you to revisit the question, what are we supposed to try at this point in terms of how to meet that standard? What is that standard? And if we can't do that at this point, this process can't proceed. There's nothing to try, and I certainly can't guess at it. I have to have you all define it for me so that I can meet it, and that's why we're here. So I would ask that you invite Ms. Royals to have that colloquy with my client about what might satisfy her in the context of this. Do away with this violation proceeding. Figure out what can be done with the work in place and the appropriate engineering that may satisfy her with regards to those questions if she still wants to hold out the prospect of a later violation if we don't meet what it is that she now articulates. I have problems with that legally, but my clients may be willing to undertake that, certainly more willing to undertake that than trying to sort this all out through an adversarial proceeding. Thank you all very much for your attention, and I hope that you can come to a decision that is best for the county and best for my clients.
Very quickly.
One point I just want to clarify, based on what was said, what you need to be cautious of is if you adopt what Mr. Mead just said, the same thing Ms. Roll said, you run a problem. If that enforcement proceeding with the special magistrate is ended and it goes away, is the county enforcing its code provisions? That's what.
I'm going to call for a vote. I'm going to make a motion that we support our staff. Commissioner Lynchard, would you like to follow up?
Mr. Chairman, I just, based on everything that we've heard tonight, I don't think we're in a position to delineate what those standards are. We're not in position to do that, and that's not what we're charged with tonight. However, based on the totality of the record that was presented in our packages and then the evidence tonight, I would suggest that the board make a finding of fact that competent substantial evidence exists to support the floodplain manager's determination.
Form of motion.
Mr. Chairman, I'll second that motion.
Move without objection.
All right, I'd like to move Commissioner Lynchard's motion without objection. Hearing none from the board, motion passes.
So it will, at this point, be remanded back to the special magistrate? Is that
Well,
in our capacity to do?
I don't really know that that is in your capacity to do. I mean, you've
We've upheld her determination.
That's all. All right. Roy, we're going to leave this in your capable hands then from here on. All right, we're going to move on to the final item this evening. Final item this evening is recommend the ordinances. Do I have any objection to the recommendation of the ordinances that we discussed this evening? Hearing none, I'm going to move them without objection. Hearing none, they pass. And at this time, we are adjourned.